So welcome to the directions hearing for the Victoria Murray Floodplain Restoration Project Environmental Effects Statement Central Package. I will refer to the Environmental Effects Statement as the EES. So the EES Central Package includes the proposed Hattah Lakes North Floodplain Restoration Project and the Belsar-Yungera Floodplain Restoration Project. My name is Lisa Kendall and I am co-chair of the Victorian Murray Floodplain Restoration Project Standing Inquiry and Advisory Committee, and I'm chair of the EES Central Package. The Victorian Murray Floodplain Restoration Project Standing Inquiry and Advisory Committee acknowledges the traditional owners of the land and waters that we meet and work upon, and particularly the lands and waters that are the focus of this committee's work. We acknowledge and pay our respects to their elders, past and present, and the wider Aboriginal community. So an invitation to today's directions hearing has been sent to all submitters, and a publicly accessible link has been placed on the Engage Victoria website. The directions hearing and the main hearing will be conducted in public, and we may have a number of observers present here today as well. And I'd just like to say welcome to everybody observing and attending. There's just a couple of housekeeping matters I need to run through before we start to move into the business of the directions hearing. So firstly, in using Zoom as our video conference tool, as I mentioned, parties and interested observers can observe and participate in the directions hearing using the link provided. If you are a submitter, if you could please include your first name and your last name in the participant list, and also to indicate if you're representing an organisation, so then the committee can easily identify you. Instructions were provided in the letter advising of this directions hearing if you need to check the process for setting up your name. If you do wish to speak during the directions hearing, you can let me know by using your raised hand function, which is an electronic function on Zoom. Also, if you have your camera on and put up your real hand, I will keep an eye out for somebody, or if you're wishing to ask a question. You're also welcome to use the chat to just put your name in and to indicate that you would like to ask a question, but I ask that all parties not use the chat function for any other purpose. If you do indicate that you have a question, as I mentioned, I'll come to you at an appropriate time for you to ask that question or to speak. I'll ask, with the Zoom platform that we're using, parties and people observing may have cameras on. I'll just ask if anybody observing could please have their camera and microphone off throughout. And I'll give you a phone number for if you are experiencing any technical issues, and it's the contact technical support at the proponents Lower Murray Waters phone number is 03 5051 0700. And just a couple of meeting online etiquette rules that will assist everybody to make sure this morning runs smoothly. If we do have too many participants with their camera on at once, it can cause some delays and glitches. So we may need to ask the people who are not speaking to turn their cameras off, and we will just leave the members of the committee and the person speaking with their cameras on. I've asked participants to please not interrupt anybody who's speaking, but to use the raise hand function as we've discussed. If you're having issues using the raised hand function or putting your name in the chat, please email the Planning Panel's office, and the email will be the one that's on the directions hearing notification letter, which is vmfrp.siac@delp.vic.gov.au, and somebody will let us know that you are trying to speak. So we've finished with the housekeeping. I'm going to move into some introductions. As I mentioned, my name is Lisa Kendall and I'm chair of the committee considering EES Central. In the invitation to today's directions hearing, submitters were advised of members of the committee appointed to hear the matter. And with me today are committee members Michael Kirsch, Jeffrey Carruthers, Alyssa Bell, Ian Ham and Sandra Brisger. So Michael Kirsch is an additional member who's been nominated to sit on the committee and is participating as a deputy chair. For the benefit of parties, the committee's members' preferred term of address is member. For Sandra Brisger, it is Dr. Brisger, and for myself, either member Kendall or chair. So by way of further background, I am a strategic and environmental planner with over 25 years experience, currently working as a senior panel member with Planning Panels Victoria, and have previously worked as a sessional panel member and in various roles in government and the private and not-for-profit sectors. So I'll now ask other members here to introduce themselves, and I'll start with Deputy Chair Member Kirsch.
Thanks, Chair. My name's Michael Kirsch. I'm a strategic and statutory planner with 30 years town planning experience. I'm also a senior sessional member of Planning Panels Victoria. I've been involved in a number of EES matters and also in a range of, I've been involved in a number of ministerial advisory committees.
Great, thank you very much. Member Carruthers.
Good morning, thank you, Chair. I'm a chartered professional civil engineer and a fellow of Engineers Australia, and I've also had additional studies in urban planning and management. And I've been a sessional member of Planning Panels Victoria since 2003, and I'm also a VCAT sessional member in the Planning and Environment Division since 2016. And I also have been appointed to a broad cross-section of planning panel matters and ministerial advisory committee matters. Thank you.
Thank you, Member Carruthers. Member Bell.
Thank you. Good morning. My name is Alyssa Bell. My background is in science, majoring in marine and freshwater ecology and law. I have been a sessional member since 2018. I have over 17 years experience in environmental impact assessment, environmental management and policy. I've worked as a private consultant and joined state government in 2010. And I've also worked on a number of EES matters as a sessional member and ministerial advisory committees. Thank you.
Thank you. Member Ham.
Thank you, Chair. Good morning, everyone. My name is Ian Ham. I was a public servant for over 30 years, 20 at executive level. Relevancy, or most relevant to this hearing, is that I was the Deputy Director of Aboriginal Affairs Victoria when the Aboriginal Heritage Act came into being, and was the Executive Director of Aboriginal Affairs when the Traditional Owner Settlement Act came into being. And I do I've done a number of panels in the past as well. Thank you.
Thank you very much. And Dr. Brisger. We can't hear you, Dr. Brisger.
Sorry, I should operate my Zoom properly. My name's Sandra Brisger. I've been an environmental consultant for over 30 years with experience in environmental science and management. And I've got specialist expertise in rivers and floodplains. I'm a sessional member of Planning Panels Victoria and sat on quite a number of EES matters, and I'm a director on several Victorian government boards.
Thank you. So today the committee is being assisted by Ms. Amy Selvaraj, Senior Project Officer at Planning Panels Victoria. And on behalf of the committee, I'd like to thank Ms. Selvaraj for all of her assistance in organising and preparing for today's directions hearing. As I mentioned, if you do have any, well, that was in relation to the technical matters, but if you do have any queries after today about the hearing, please contact Ms. Selvaraj with the email address that I mentioned earlier. So I will now ask those who will be intending to speak at today's directions hearing to introduce themselves and to indicate who they are representing. If you do have a preferred term of address, I ask that if that could please be advised during introductions. And I will ask parties to speak to procedural matters during and later in the directions hearing. So if I could ask parties to just to do introductions at this stage. So thank you, and I'll come to representatives for the proponent to start with.
Thank you, Member Kendall, and good morning to you and the committee.
Welcome, Mr. Townsend. Mr. Townsend, your audio is very quiet. I'm just wondering if there's anything you can do. I don't know if others are finding that as well. Yeah.
Is that better?
Yes, much better. Thank you.
Thank you, and my apologies. There was a glitch or two at our end here. I'm confident it's us. So I'll let you know if there's any problems, but hopefully we're going okay. I'll start again. My name's Chris Townsend. I'm a barrister. You will be seeing me throughout the hearing with a second barrister, Robert Forrester, who is attending today but not there on screen. We're instructed by Clayton, Sally Ann Everett is the partner there, and Will Bartley. So you'll see their names from time to time, and also a number of people from the project team. We represent the project, and the lead proponent for the project is Lower Murray Water. So they're our actual client. But as you've seen from the material, somebody's got a mute there. But as you've seen from the material, as the lead proponent, we coordinate and speak for, where appropriate, Mallee CMA, Parks Victoria and DELP in certain capacities. And at the whole package level, it incorporates also Goulburn Murray Water and North Central Catchment Management Authority. The reason I say all that now, Member Kendall, is that so you're aware that for the purposes of the hearing, so far as possible, you will hear about the project through Lower Murray Water, assisted by agents as necessary, or agencies as necessary. But we would let you know from time to time if a matter is beyond the scope of the project and is a matter for direct reference to those agencies. But so far as possible, we'll be trying to represent the project on behalf of the lead proponent, being Lower Murray Water. So I hope that's sufficiently clear.
Thank you, that's great. Thank you, Mr. Townsend. So others who are wishing to speak and participate in today's directions hearing, if I could ask you to please put your camera on and to introduce yourselves. Okay. I can see Mr. Decker. I'll hand to you for you to introduce yourself.
Apologies here, I just quickly grabbed the headset. Yes, my name's Stuart Decker. I'm the Program Manager for the Victorian Murray River Floodplain Restoration Project. I represent the interests of the Minister for Environment and Climate Action and Environmental Policy Matters relevant to the Secretary to DELP. I think we're sort of in forums like this, we're often referred to as the DELP environment part of DELP. I know that there are various representations within DELP as part of this project, so I'm hoping DELP environment might work for this forum as a general reference to the areas in which I'm representing. I think that's a good enough introduction for me now, and
thank you, Mr. Decker.
Happy to join in a bit later. Thank you.
Fantastic. Thank you very much. Dr. Kelly, welcome.
Hi. I'm participating as the chair of Friends of Niavinifera Park. We formed in 1996, and I was part of that original forming of a group. We have interests along the whole Murray, both sides of the river. We don't just deal with Niavinifera Park, but our 25 years of working on that park has given us a lot of knowledge. We have been...
Thank you, Dr. Kelly. I might not get you to do an expansive introduction at this stage, if that's okay. We really just need to know who's in the room, and I will come to you throughout the directions hearing to speak to any matters of interest, procedural.
I just wanted to say that I'm not a lawyer, I'm not a government employee, so I will need a lot of assistance understanding the procedures in this matter. So yeah, tick me off when I'm on the wrong track. My personal experience is as a health practitioner, but also as 25 years as an environmentalist, and particularly in river and floodplain and this Murray-Mallee region. I've also done time on local government, council.
Great, thank you and welcome. Yeah, as I mentioned, as we talk through some of the procedural matters this morning, if there's things of particular interest, you're welcome to contribute to that conversation. And I know that Ms Selbridge in the Planning Panel's office will continue to assist with any to guide you as required throughout the process behind the scenes as well. So thank you. Ellen Mabry.
Good morning, Member Kendall. I'm Ellen Mabry, a Senior Specialist Lawyer at Environmental Justice Australia, appearing for Environment Victoria and joined by my colleague, Natalie Hogan.
Great, thank you very much. Welcome. I'll just give it a moment to see if anybody else would like to introduce themselves. If you are intending to speak or contribute to the discussion at all this morning, as we work through some of the procedural aspects of the hearing, it would be appreciated if you're able to introduce yourself now so that we know who you are when the time comes. I do know that we have a couple of people attending later during the morning, so if they do intend to speak at that time, I'll ask them to do a very brief introduction. But as no one else is turning their cameras on, I will continue.
Excuse me, Lisa, could you just say how long this will take?
Dr. Kelly, it's a little bit hard to anticipate. It depends how much discussion we need to have around various matters. It could be up to a couple of hours, but that's a guess, and we may have a break as required. Thank you. Douglas Frood, I can see that you have popped your camera on, so I'll come to you for your introduction.
Hello, yes, sorry, I couldn't find the hand button on my screen. Yeah, I'm an ecologist who's spent a lot of time on the floodplain and been involved in descriptions of the EVCs, or have described the EVCs along the Murray floodplain, and also co-author of a document on the preferred flood inundation regimes, water regimes for the EVCs. So that's
great, thank you.
Really?
Thank you, Mr. Frew, welcome. And yes, feel free to participate, pop your camera on as needed throughout this morning's directions hearing.
Okay, now I can't find a place to put my hand up. How do I?
Okay.
What do I do? What's appropriate?
So down the bottom of the screen, there should be a little button with a face on it called reactions. And when you click on that, the bottom bar should say raise hand.
I miss out on that.
Okay,
yeah.
That's okay. If you put your camera on, I will keep it. We don't have many parties with cameras on, so I'll keep an eye on it. And if you please just pop your real hand up and I'll come to you when I can. Thank you. So to run through some declarations, the committee has been appointed to this inquiry because of our experience and independence. Two committee members have declarations to make, and I will ask them to briefly explain these now. So starting with Member Bell.
Apologies for the delay. For the record, I've previously donated to Trust for Nature, and a property with a Trust for Nature covenant has submitted to the EES and is subject to some inundation from the project. The donations that I've made have been in general in nature to the Trust for Nature and not to any specific properties.
Thank you, Member Bell. And Dr. Briscoe.
Yeah, thank you. I'm a trustee of the Trust for Nature. Trust for Nature is Victorian Government statutory authority, which was established under the Victorian Conservation Trust Act, and the role of a trustee is similar to the role of a director.
Thank you. So no other committee members have any declarations to make in relation to the matter, but I will pause for a moment and ask if any the proponent or any party has any concerns or questions to raise. No. So I will now just talk briefly through the role of the committee, and then I will outline the purpose of the directions hearing and the agenda for today. So the Standing Inquiry and Advisory Committee has been appointed both as an inquiry under the Environmental Effects Act to assess the environmental effects statement prepared by the proponent for the projects, and also as an advisory committee under the Planning and Environment Act to assess the draft planning scheme amendment intended to facilitate the projects. So I will refer to us from now on as the committee. Our role and purpose is set out in more detail in the terms of reference issued by the Minister for Planning on the 16th of August 2022, and the terms of reference are available on the Engage Victoria website. The committee is required to hold an inquiry into and provide an integrated assessment of the environmental effects of each of the projects. For each assessment package, the committee is required to review and consider the relevant environmental effects statement together with the associated technical appendices and other exhibited documents and submissions received in relation to the projects. The committee must consider and report on potential environmental effects and benefits of each project, their significance and acceptability, having regard to evaluation objectives in scoping requirements and the relevant policy and legislation. We must also consider and report on the potential environmental effects for each project on relevant matters of national environmental significance protected under the Commonwealth Environmental Protection and Biodiversity Conservation Act. The committee must identify any measures, including any necessary project modifications it considers necessary and effective to sufficiently avoid, mitigate and manage the environmental effects within acceptable limits for the projects that are subject to the EES. It must advise on how any identified measures relate to relevant conditions, controls and requirements that could form part of the necessary approvals and consents. It must consider the merits of the draft planning scheme exhibited with the EES, which have been prepared to apply a specific controls overlay, incorporated document and establish planning approval for the projects. It must undertake a strategic assessment of the draft planning scheme amendments exhibited with the EES against the strategic considerations in Planning Practice Note 46 and other relevant considerations. It must consider any other relevant issues raised in submissions. As I mentioned, review the content of the draft planning scheme amendment, sorry, slightly repetitive there, and recommend any changes to the planning scheme amendment, draft planning scheme amendment that it considers necessary. Under the terms of reference, the committee may inform itself any way it sees fit, but we must review and consider for the amendment packages the referral letter from the DELP Impact Assessment Unit, the exhibited EES and the corresponding draft planning scheme amendment, all submissions and evidence provided to the committee by the proponent, state agencies, local councils and submitters, any known views of the registered Aboriginal parties, traditional owner groups, or to seek the views of the registered Aboriginal parties or traditional owner groups if they're not already known. Any information provided by the proponent and parties that responds to submissions or directions of the committee, and any other relevant information that is provided to or obtained by the committee. The terms of reference state that the committee must conduct public hearings, and these must be conducted in accordance with the following principles. So they must be conducted in an open, orderly and equitable manner in accordance with the principles of natural justice. The public hearing will be conducted with a minimum of formality and without legal representation being necessary for parties to be effective participants. And the committee process is to be exploratory and constructive, with adversarial behaviour discouraged and with cross-examination or questioning regulated by the committee. So clauses 47 to 49 of the terms of reference outline what the committee must include in its report. The committee must produce a report of its findings and recommendations to the Minister for Planning to inform assessment under the Environmental Effects Act, and in turn to assist the Minister to make a decision about the planning scheme amendment for the projects. The report must be provided within 40 days of the last day of the hearings. So we encourage all parties to read and be familiar with the scope of matters that the committee must consider and the matters that the committee must report on when preparing our report to our report for the Minister. So just some scene setting there before we get into the nuts and bolts. So today's directions hearing, the purpose is to introduce the committee, to consider any preliminary or procedural matters, to make arrangements for the hearing and site inspection, to consider any timetabling issues, to give directions about conduct of the hearing and exchange of information before the hearing, and to answer any questions that people may have. So it's not the purpose of this directions hearing for participants to give submissions or to offer an opinion about the projects. That opportunity will come at the main hearing. So in terms of the agenda for today, we will provide some background to the process, including an explanation of the proposal. We will then outline the information we've received so far, and we'll outline the broad issues that have been raised in submissions. After that, we will deal with a range of procedural matters, explain the site inspection, make arrangements for the hearing, explain the difference between advocates, experts and submitters, and give you some information about how cross-examination will occur at the hearing. So we'll give you information about how to make a submission at the hearing, have a discussion around providing information to the committee in the lead up to the hearing, including the exchange of evidence, and outline the directions that we propose to make. So I note, and you will have noticed already, that I will need to do quite a bit of talking to explain what the committee process, but there will be a time for participants to ask questions and to provide comment. Depending on how we go, we may need to take a break. So now I'm going to explain the proposal before the committee. So the Victorian Murray Floodplain Restoration Project consists of 9 discrete projects over 4 packages, including a single environmental effects statement covering both Hattah Lakes North Floodplain Restoration Project and Belsar-Yungera Floodplain Restoration Project. The other packages include a single environmental effects statement covering both Lindsay Island Floodplain Restoration Project and Walpola Island Floodplain Restoration Project. There's also a single environment report covering Naya, Vinifera and Burra Creek floodplain restoration projects, and a single environment report covering Gumbour National Park and Guttram Benwell Forests floodplain restoration projects. I'm very happy for my pronunciation of any of those places to be corrected by parties who are more familiar with them. So the Victorian Murray Floodplain Restoration Project is being implemented as part of Victoria's obligation under the Murray-Darling Basin Plan. The Basin Plan sets out the sustainable diversion limits, which are the amount of water that can be taken from the Murray-Darling Basin each year, and the projects form part of the greatest sustainable diversion limit adjustment mechanism under the Murray-Darling Basin Plan. The terms of reference for the committee outline that the structure and implementation of the Murray-Darling Basin Plan, the Sustainable Diversion Limit Adjustment Mechanism, and the Victorian Environmental Water Framework are outside the scope of matters to be examined by the committee. So they are only context for these projects. The committee will ask the proponent for some additional background information about these matters to help us better understand the context for these projects. The committee understands these projects aim to restore a more natural flooding regime to approximately 14,000 hectares of high ecological value floodplains along the Murray River through modification of existing and construction of new infrastructure. So the projects will include construction of infrastructure such as channels, regulators, containment banks, drop structures, spillways, temporary or permanent pumping stations, laydown areas, site compounds and workforce facilities. Construction and upgrade of access roads will be required, as well as the removal of native vegetation in construction areas. Sites will also need to be established to supply fill material to support construction. So the package before the committee and the process that we're discussing today, as I mentioned, is the EES Central package, and that was referred by the Minister to the committee on the 28th of September 2022. It consists of two projects, the Hattah Lakes North project, which is located on the western side of the Murray River in northwest Victoria, between Robin Vale and Red Cliffs, approximately 75 kilometres south of Mildura. The project involves works to facilitate the inundation of approximately 1,130 hectares of high ecological value Murray River floodplain, including the Chelka North and Lake Bulka water management areas. The project is located entirely in the rural city of Mildura and in the Mallee Catchment Management Area, the Mallee CMA. It is designed to build on the benefits of the Living Murray initiative, which was constructed in 2013 and which allows watering of approximately 6,000 hectares of the central and southern Hattah Lakes floodplains. So in relation to the Belsar-Yungera project, this is located in the northwest of Victoria near Robin Vale in the Lake Powell district, approximately 30 kilometres upstream of Euston Weir. The project would involve works to facilitate the inundation of approximately 2,374 hectares of high ecological value Murray River floodplain. The project is located almost entirely within the rural city of Swan Hill and the Mallee CMA region, with the exception of the temporary suction line, which during pumping events would be located on the bank of the Murray River within New South Wales and therefore within Balranald Shire local government area. The project involves a number of water management areas, infrastructure and a number of operating scenarios. So both projects are located in areas where a registered Aboriginal party has not been appointed, but we understand there has been consultation with traditional owners and Aboriginal parties and or organisations. So the key approvals that are required for the projects, I'm just going to run through those. On the 6th of December 2020, the Victorian Minister for Planning determined that a single environmental effects statement was required for the projects under the Environmental Effects Act. At the conclusion of the EES process, the Minister for Planning will publish and issue an assessment to inform statutory decisions on Belsar-Yungera and the Hattah Lakes North projects. And that assessment would need to be, and the statutory decisions would need to be made by the relevant ministers and statutory authorities and agencies. So other project approvals include the Planning Scheme Amendment under the Planning and Environment Act, approval of cultural heritage management plans for both projects under the Aboriginal Heritage Act, approval for both projects under the Environment Protection Biodiversity Conservation Act, and approval under the Environmental Planning and Assessment Act in New South Wales. I'll now run through the submissions and information that has been received or provided to the committee. So the committee has received a copy of the exhibited EES material for the projects, including all of the various attachments and specialist assessments. We have a copy of the draft planning scheme amendment, which is known as GC 202, including the proposed incorporated document, which is found in volume 4, attachment 4, Roman numeral 4 of the EES. We also have copies of the submissions received. I'll just run through what we've received in relation to submissions. So the EES and draft planning scheme amendment was placed on exhibition for 30 days from the 3rd of October to the 14th of November on the Engage Victoria website. The committee has received 21 submissions and the committee has received 2 extension requests, and these will be discussed shortly. In addition to the terms of reference, copies of all the submissions are available on the Engage Victoria website. In a few cases, personal information has been redacted from the submissions before placing them online to ensure that we meet our privacy obligations. Copies of the submissions have been provided to the proponent and the following agencies as required under our terms of reference. So the copies have also gone to the DELP Impact Assessment Unit, DELP Regional Planning Services for Loddon Mallee, First People State Relations, the relevant councils, so Mildura and Swan Hill, and also Parks Victoria. So I'm going to run through a summary of the issues that have been raised in the submissions. So this is no comment on these issues, just a list of them as the committee has understood them in its review of the submissions. And there's a little bit to run through, so apologies. I will just keep moving through as quickly as I can, but hopefully not too fast. So under the theme of context and background, issues have been raised in relation to the strategic justification, feasibility and viability of projects in the context of the Murray-Darling Basin Plan and the associated sustainable diversion limits. Whether the water accounting components stack up and whether the water allocations are guaranteed. Whether an environmental effects process is warranted and concern about the timeframes associated with the process. Implications of the current floods, how the committee assessment process fits with other approvals, including those required under the New South Wales legislation, and how the multi-jurisdictional approach to water management will be managed. Under the theme of the environmental effects statement and requirements for integrated assessment, issues have been raised relating to whether the EES adequately considered all legislation and international obligations, whether cumulative and indirect impacts have been adequately assessed, whether climate change has been adequately taken into consideration, whether alternatives have included consideration of no project or full water recovery scenarios, and whether the EES meet required minimum standards or scoping requirements. Issues have also been raised in relation to the EES methodology and the technical assessments, such as whether the entire area has been adequately surveyed, and also questions regarding specific methods. In relation to cultural heritage, issues have been raised relating to the adequacy of consultation with traditional owners, whether traditional owner knowledge has been adequately addressed in the planning, delivery and evaluation of the VMFRP. Whether the cultural heritage assessment has been informed by adequate survey and satisfies the Aboriginal Heritage Act requirements, and concern that the project fails to demonstrate a proper understanding of the difference between the rights of traditional owners for country and the legislative requirements. In relation to biodiversity, issues have been raised in relation to the implications of loss of habitat for listed species and communities, implications of large tree removal, whether the project is adequately focused on avoidance and minimisation of native veg, whether the proposed conservation works exemption is appropriate, whether the projects do adequately take into consideration implications relating to changes to ecological systems, such as default triage implications and ecological conversion. So whether the ARI technical report has been applied appropriately, whether the net environmental benefit assessment is adequate. Submitters have asked for comparable examples of infrastructure-based solutions for environment, or have provided examples of comparable infrastructure-based solutions for environmental watering, and stating that they have failed. There have been issues relating to matters of national environmental significance, specific issues relating to the arid bronze azure butterfly, issues relating to habitat and fauna movement, specifically fish and turtles, and concern about increased pest plants and animals. So there's just a couple of others that I'll run through. So issues relating to whether the project results in any loss of agricultural production, whether the monitoring and evaluation requirements in the environmental management framework are adequate. There are some issues, site-specific issues, issues relating to community access, use and management of public land, and issues to do with the community consultation and stakeholder engagement process. So quite a long list. I thought it was worth taking parties through that though. And I will ask at this stage if there are any key issues or critical issues that I did not touch on that you would like to just make sure that the committee is aware of. No, great, thank you. So I will now run through some procedural issues about making arrangements for the hearing and the site inspection. So the procedural issues that we will talk through, I will just list them before I do so that you know what we're going to cover. So firstly, the late...
Excuse me, Lisa.
Yes.
In that list that you just read out, did you mention taking into account the current flood?
I did, Dr. Kelly.
Sorry, I missed it. Thank you.
No, that's fine. Thank you. Thank you. It can be a bit of a delay with our online meetings as well, so I'm trying to keep my eye on a few things at once. Okay. I'll just keep moving through. So some procedural issues that we'll now cover off and relate to late submissions and any requests for extension of time. The role of advocates, experts and submitters. A submitter requesting to appear as a witness. The proponent and partner organisation submissions. Government agency submissions. The request for further information from the committee. The traditional owner invitation or correspondence to ensure they're aware of this process. Recording of the hearing and the site inspection and visual material. As I mentioned earlier this morning, I will come to parties if there is anything that we don't cover off on through my notes, that I will come to you if there are any other procedural matters that you would like us to discuss this morning, but I'll do that towards the end. So firstly, late submissions and requests for extension. So as mentioned above, the committee has received 2 requests from individuals seeking an extension to put in a submission. So firstly, the Friends of Naya Vinifera Park lodged a submission within the exhibition period, but also sought an extension of 3 months. We had an inquiry from the Sustainable Living in the Mallee about making a late submission, but they have not yet put in a holding submission or provided the committee with an indication of how long an extension they need. In terms of extensions to the period of exhibition, which is obviously closed, it's not something the committee can change, as the exhibition timeframes are set by the Minister for Planning. So any requests relating to exhibition periods needs to be processed through a different process to the committee. So firstly, before I do come to the parties who have indicated or put in that request, and Dr. Kelly, I will come to you in a moment to talk to your original request, but are there any other requests for late submission? Okay. So on that note, I will come to you, Dr. Kelly, to ask if you could briefly speak to whether you are still seeking an extension, and if so, if you could please clarify the request and the reasons for that and how long you're requesting.
Thank you, Lisa. Well, when I asked for an extension of the exhibition, I think I was a bit confused about the terminology. I think I meant an extension for a submission. But I mean, it would be better to have an extension for the exhibition as well, because I didn't actually get down to the local library to look at the paper documents. And I did find it quite difficult to navigate them online. As I said in my request for an extension, we are in an emergency situation here, and we have been for over 6 weeks. I'm not sure if you can really understand, unless you're from up here, what it's like. So that has impacted us a lot in being able to meet as a group to discuss this submission and the process. We're all doing, you know, our lives have been changed in the things we're doing because we're volunteering to assist with flood stuff, and we are being impacted a lot in regards to travel, in regards to things being cancelled. For instance, the community meeting here in Swan Hill was cancelled. I don't know, was that the VMFRP community meeting regarding these submissions and the EES?
Yeah, I think that will be the one you're referring to. Thank you.
Yeah, and I didn't, I'm not sure if I was able to participate in the online one that was put on.
Yeah. So Dr. Kelly, can I just confirm you did put in a submission during the exhibition period? Was that, would you consider that a holding submission, or was it relatively complete and something that you would supplement with further information at the hearing?
Yeah, I could. So, it was an incomplete one, as I said in it. I said it's not complete. It's actually what I sent to the EPBC submission, and it's just the Belsar. It doesn't really go into Hattah. So I put it in because I thought we didn't want to miss out altogether if we weren't granted an extension. So I put that in, but I would like to modify it and add to it. And if I could have that permission to do that, that would be good.
Now, Dr. Kelly, what time frame are you asking for to provide that? At the hearing, you can expand on your original submission. It is important, if you have any particular issues that weren't identified in your original submission, that the committee and the parties are aware of that before the hearing.
Yeah, I think I would probably, I would like to submit another one before the hearing and then be able to speak to that. I would like to expand more on the issue of the recent floods, because I think that hasn't been, I haven't really elaborated on that in this submission, because this submission was sent in exactly 2 years ago to the EPBC. So there's been a 2-year gap there between when this was first written, and so it needs tweaking.
Yeah, but not a substantial overhaul or a great range of additional issues by the sound of it.
Well, there could be, because this submission is really just considering Belsar. It's not a submission on Hattah, the Hattah part of it, because you've bundled them now. So it may have quite a bit more information in it, and I will need we will need some weeks to do that. The other thing is, you know, it's very tight, and you're putting it on in January and December and January. So this whole thing's a bit like a steam train coming towards us. And
Thank you, Dr. Kelly. And the committee is certainly aware of the time of year that the process is running through, and that, we're happy to talk about some flexibility with the timeframes around providing that further information. I would like just to seek the views of the proponent and other parties before we do discuss what that looks like. So, Mr. Townsend, I'll come to you. If you could just provide me with your views.
Look, Member Kendall, I think a practical approach is emerging from the submissions that have just been made to you. It seems to us that Dr. Kelly doesn't really need an extension of time as such. The submission's in, but needs time to elaborate or expand on the submission. And all we'd ask is that when you do your timetabling and scheduling for the hearing, that's organised in a way that gives us some time to see it, but we're otherwise happy to cooperate with more time being provided we see it in advance of any expert witnesses being called.
Yes, thank you. So that's probably the critical thing, Dr. Kelly, is that we receive any, have an understanding of any further issues that you're intending to present to the committee before the expert witnesses do circulate or consider the submissions and prepare their expert witness statements. On that basis,
could I just make a comment that looking at the list of people who have submitted, do you take anything from what can you deduct from how many submissions you got and who they were from? There's not many local submissions. There's nothing from local government because our whole area is in an emergency situation. So, you know, I do want that genuinely taken into consideration, because to me that's not many. You didn't get many submissions.
Thank you, Dr. Kelly. Yes, we've certainly heard your views on that, and it may be something certainly the proponent will address around the process, I think, of community engagement throughout in the lead up to the committee process. So, yeah, we might, I'm just going to park that particular issue of staggering. Oh, no, actually, I'd be happy now to discuss that idea of in principle, stating that if you could provide an expansion on your current submission, say a week before the expert evidence is due. Mr. Townsend, do you think that's enough time?
Yes, look, it is. Look, frankly, we would cooperate with the committee on whatever time you chose to give. The difference is whether you want it in advance of the expert witness reports being filed, which is what you're suggesting now, and if it can be, 5 business days or so before that, that certainly helps. The option you have is alternatively that you would allow us to have the witnesses respond in their evidence to
yes.
Something that came later, and we can accommodate that if you prefer, Member Kendall, but we're in your hands either way.
Okay, thank you. And I'm just going to open up and quickly check the dates that were flagged for that original evidence. Sorry, I don't have that open in front of me. You do, Mr. Townsend, you're welcome to tell me if you...
You've got the 15th of December.
15th of December.
As the proponent's evidence, and the 19th of December for other parties filing evidence.
So I'll come back to you, Dr. Kelly, just to check if around the 10th of December would be realistic for you to provide an expansion on your original submission, noting that at the hearing process, as I said, you get the opportunity to expand further on the issues. It's really just making sure the issues are on the table.
Yeah, sure. I mean, could I ask why it's being conducted so close to Christmas, January? Why is it being done over this kind of time?
Yeah. So, Dr. Kelly, the committee has, with the terms of reference, needs to work through each of the matters when they are referred to them within the timeframes that we are given. I don't know whether Mr. Townsend, on behalf of the proponent, could talk more broadly to the timing of this project and in the context of the broader VMFRP.
I imagine I could with further instructions on a particular matter. I'd answer it this way for today, that it is, well, I've been in a number of major projects over many years, and we hit this time of year, and the major projects and major hearings do not stop, and it's not uncommon for us to be dealing with hearings straddling this side and into the new year in any year. So it's not unusual, if I can put it that way, for projects or processes or environmental inquiries to hit this time of year. It's just it's another day at the office, if I can put it that way. As to the project, though, there are, and we can probably help that in our when the Part A submission's filed, if it hasn't been picked up in the exhibited documents, there are other Commonwealth and state obligations that are at play here as well. So there are external timeframes that are relevant to the timeframes under which the EES is being conducted, and we can expand on that in due course. But I am able to say that it is time critical, and but that the process-wise, it's not the only project certainly that I've been associated with that is time critical and straddles over the Christmas break.
Thank you, Mr. Townsend. So, Dr. Kelly, we certainly hear your concerns and understand to the extent that we can, if we're not living in that part of the world, the situation that you're experiencing. The committee has certainly been within the scope of its terms of reference, looking to be flexible and I acknowledge Mr. Townsend's comments in relation to your further submission and information and some flexibility around that. And certainly I know that the Planning Panel's Victoria office has been in discussion with anybody who's come to it for further information about our process and what we can do to support them to make a submission. So before we move on, I'd just like to come back to that timeframe for further submission. And Dr. Kelly, with the option of either providing the additional information 5 days before the expert's evidence is due, so around so it's a Thursday actually in terms of the expert report. So perhaps the Thursday before, which would be the, I think it'd be the 8th of December. So if that is an option, if that's not an option, I'm sure the committee is happy to entertain that being provided later with the option for the expert to provide comment on that at a later stage.
Yeah, I'll comply. We'll comply with that. It'll be difficult, but I don't think I have to explain to Lower Murray Water what's going on up here. Yeah. I think they pretty much understand. Yeah. Can you explain who are the expert? What is this expert thing?
So I'm actually going to talk through the expert evidence shortly, and I'm going to talk exactly, actually that's the next item on my agenda, is to talk explicitly about each of those participants in the hearing process and what their role is. So the proponent will be calling experts to look at specific areas and to advise the committee on how it may respond to some of the issues before it. So I'll talk to that in a moment. If you do have any questions after that, please ask them.
Thank you.
So I just need to check if there were any other requests for extension that we need to hear from. I don't believe that we have a representative here from anyone else who has indicated that they may. So, for example, Sustainable Living in the Mallee, I don't think we have a representative from them.
I would be happy to speak for Sustainable Living in the Mallee, as I'm a member of that group too. It's based in Swan Hill.
Thank you, Dr. Kelly. So we haven't received a formal submission from them, but there were inquiries made. Do you understand whether there's still an interest in making a late submission?
Yes, there is an interest if that would be granted.
I think we can certainly work to the same time frame that we've just discussed, but I would ask them to submit a request for that if there's as soon as possible, potentially with a holding submission just with dot points around the key issues and then the same time frame as for the other submission.
Yep. I mean, I would like to ask whether you actually legitimately do want community input in this process, because giving 30 days and then giving, you know, not really understanding the need for an extension is you haven't received many community submissions, and I'd like to point out that that is why. So do you actually genuinely want community input?
No, Dr. Kelly, that's exactly what our job is. The committee is very committed to a genuine process of community engagement. As explained by Mr. Townsend, there's several steps to the process and a number of other interrelated processes. So within the bits that we can control ourselves, we're very interested to do what we can to support community submissions. So if there are any other parties who haven't been engaged so far that you know are wanting to, if they will need to contact us urgently to indicate that and to put in a formal request to be granted that same extension that we've just discussed.
Well, there's not a lot of, yeah, it'd probably take me longer to explain that than you have, so you can just carry on.
Thank you, Dr. Kelly. And of course, during your submission at the hearing, you're welcome to cover off on any matters that you think should be considered by the committee. So that will be an opportunity for you to speak in detail to any of the implications of things you've been raising.
Thank you.
Thank you. Great. We're just going to move in to discuss now the difference between advocates, experts and submitters. So for people who have not participated in a hearing like this before, I'll explain the difference. Firstly, advocates are those who are acting on behalf of a client. So advocates generally run the case and may or may not call an expert witness. They express a view about the proposal, but they don't provide expert evidence. So, for example, in the matter that we're considering, Mr. Townsend will be the advocate for the proponent, so Lower Murray Water in this matter. Expert witnesses are those who provide evidence in a field of expertise. Common areas of expert evidence include biodiversity, social impacts, traffic, economics and the like. Submitters are those who wish to express an opinion about the proposal. Of the three, only expert witnesses can be cross-examined by other parties. So this allows their evidence and opinions to be tested and weighted accordingly by the committee. Expert witnesses who are called by a party are independent and their primary duty is to the committee, not to the party who calls them. The committee may ask questions of advocates and submitters to make sure that we fully understand your submissions, but other parties are not allowed to ask questions of advocates or submitters. So to be very clear, expert witnesses are the only participants in the hearing process who may be cross-examined by any party to the hearing. So we did have one request from a submitter to appear as a witness, and I believe that Miss Fiona Murdoch, who was not with us at the beginning of the hearing, may have joined the hearing, and if so, could I ask you to please turn your camera on?
Sure, it's Dr. Murdoch here.
Dr. Murdoch, welcome. Great, thank you, I can see you. So Dr. Murdoch has requested to appear in relation to her submission as a witness. Dr. Murdoch has made a request to be heard in relation to her submission and has nominated herself as an expert. So Dr. Murdoch has a PhD in the restoration ecology of semi-arid woodlands and has been studying the arid bronze azure butterfly for several years. So I have a few questions for you, Dr. Murdoch, so that we can explore your role in the hearing and make some decisions together about that. So just to confirm, Dr. Murdoch, that you're intending to present your expert opinions to the committee during the hearing?
With regards to the arid bronze azure butterfly, yes.
Yes, okay. So if that's the case, the committee would direct you to circulate a written expert witness statement at the same time as expert evidence is circulated to ensure procedural fairness to the proponent and allow sufficient time for its biodiversity expert witnesses to consider and respond to the material when the proponent presents its case. So is that something that you understand, that component of the process, if you're presenting as an expert?
Yes, I do. I'm unclear of the timeframes though. I will just reiterate Dr. Kelly's comments that right in the middle of a flood emergency here, so it's very difficult for us.
Yeah. Yes, thank you, Dr. Murdoch. We certainly appreciate the challenge of that situation. Yeah. So the timeframe for circulating expert witness statements. So the proponent is required to circulate its expert witness reports by Thursday, the 15th of December. Other parties are required to circulate their expert witness reports by Monday, the 19th of December. So that would be the date that yours would be due. You would have the opportunity in advance to review the proponent's expert witness statement because it would come in the week before.
Thank you.
So if that is something that you're saying that you would like to do, we will need to talk about the process of cross-examination as well.
Yes.
So we need to discuss and decide whether you would be cross-examined on the basis that you're not being led in by a submitter, that you'll be representing yourself. So normally we don't allow submitters to be cross-examined at a public hearing, as I've just described. It is something that only happens with expert witnesses. However, we're generally able to give more weight to expert opinion if it's tested through cross-examination. So my question for you, Dr. Murdoch, is whether if you're intending to present your expert opinions to the committee, are you comfortable being cross-examined by other parties?
Yes, I am.
Okay. So just to note that if you are willing to be cross-examined, we might need to allocate a longer time in the timetable than you had requested. So I think the requested time you had was 30 minutes. Generally, it takes a little longer to present your evidence in chief, say perhaps up to 30 minutes maximum, and then allowing times for questions. I will seek the views of the proponent and comments from any other parties before we do finalise these arrangements. But before I do, I understand that Mr. Frood may also be interested in presenting as an expert or presenting himself as an expert. Is that correct? Mr. Frood, I can see that you have turned your camera on.
Yeah, I think I probably have a responsibility to do that if I perhaps would like my experience to be perhaps have a bit more depth of consideration. So I think I have a responsibility to choose the expert witness option.
In that, could I just ask you some questions as well then, just to be clear on what you'd be proposing to bring to the committee. Firstly, could you just describe to the committee and other parties your area of expertise and experience?
I have over 40 years of experience as a botanical ecologist. I spent a lot of time along the Murray floodplain, especially in Barmah. I undertook the mapping of most of the EVC mapping with the exception of Gunbower, but from Barmah through to the South Australian border. I described the EVCs. I've been involved in what they call wet map, the monitoring of the impacts of environmental water. Produced the vegetation component of the Index of Wetland Condition, a rapid assessment method, and undertake the training for that. So I think I've got a fairly extensive involvement in floodplain vegetation and wetlands.
Thank you for that clarification. Could I just ask then, so it would be your intention in your submission to the committee to provide what you would consider to be expert evidence?
That's correct. And that's about flood regimes and impacts on species and some ecological perspectives. I'm trying to keep this judgment free here. Ecological perspectives on some of the suggested interventions and the process as a whole.
Okay. Thank you, Mr. Frood. And the discussion that we've just had about the timeframes and for provision of an expert witness statement, is that something that you would be happy to do and could comply with?
Yeah, challenging given field work and other obligations. We've been also made a little bit, our field work's made a little bit more difficult with the flooding, but not dealing with what perhaps Dr. Kelly is the emergency they're dealing with. But yes, I believe at this stage that I can, it's essentially expanding on what I've already submitted, the dot points, and you know, perhaps including a little bit more substantial evidence rather than opinion. Okay.
So it is an option to either provide us with that additional, with the expert witness statement within the timeframes that we've just discussed, to ensure that the proponents' witnesses and the witnesses from any other parties have an opportunity to review that material as well. And also we need to discuss whether you'd be comfortable being cross-examined by other parties. I didn't state clearly in discussion with Dr. Murdoch, but if you are not comfortable being cross-examined, that is fine, but we will only be able to weigh the opinions given as a submission rather than as an expert. So that, yeah, the two things I need to check with you is whether you are able to provide the expert witness statement within the time frame, and if you are comfortable being cross-examined.
I think being cross-examined is just part of that. Well, whether it's fun or not, so irrelevant. So yes, I'm prepared to be cross-examined.
Okay, thank you.
And I believe I can expand. It's not a great deal of expansion on what I've already submitted. This is fleshing out the dot points a bit more and whatever procedures I need to do to establish my identity for the purposes of expert witness.
Okay, thank you, Mr. Frood. So is there anyone else in that situation, or I'll accept that we're discussing Dr. Murdoch's submission and Mr. Frood's at this stage? Okay. Mr. Townsend, sorry, was that somebody speaking?
Yes. Jordan Cook from the Victorian National Parks Association.
Yes, welcome.
Yeah, we intend to call two experts, excuse me, one on land tenure and legislative requirements under the National Parks Act and other legislation, as well as an ecological expert. But again, yeah, we're struggling to engage with local experts in the area due to the emergency up there. So,
thank you, Mr. Cook. I'm going to come back to you actually in a little while when we talk more broadly about the hearing process and the scheduling. The Victorian National Parks Association indicated in your request to be heard that you were intending to call experts. Yep. So we'll have a discussion in that context, but I'll just close off on the discussion we're having at the moment around the two submitters who are suggesting they'd like to present to the committee as experts. So thank you.
All right, thank you.
And Mr. Townsend, I'm interested to hear your views from the proponent in relation to the discussion that we've just had.
The overarching response is we're here to help the committee be informed, and we would operate with submitters wanting to present their cases as they see fit. But within that, I would like to say a couple of things that might assist those submitters or comfort them to some degree about whether they need to take those steps or not, and also perhaps raise some implications of doing it that they might want to think through. But having said all of those, it wouldn't be our intention to make life difficult for anybody in how they want to put their case. What I thought we should point out, though, is that really what this comes down to is a matter of weight, and we wouldn't want it to be assumed or wrongly thought that a submission can't get great weight. You know, if a submission is prepared by someone with real expertise and is persuasive and explained in matters of inquiries like this, they are commonly given weight based on their quality, and the committee has the opportunity to put questions of other witnesses based on some of that material. So we just wouldn't want it to be assumed by either Dr. Murdoch or, I'm sorry, is it Dr. Frood, I think, that they shouldn't feel diminished by doing a submission. We think that it's quite an effective way and a common way in hearings like this for information and opinions to be expressed. The second step is that when it comes to weighting expert opinion, the first question about whether it gets particular weight is how independent it is as opposed to submissions. So it should be said that in this case where you've got submitters who have an attachment to the case for their own reasons and they add their expertise, yes, it is expert, but so far as its opinion, it's not independent, so it wouldn't get that kind of weight. Usually expert evidence beyond opinion evidence is then given in circumstances where the expert has prepared documents associated with the fieldwork or the project or the exhibited material, and they're actually explaining what they did and how they got to the conclusions they arrived at. But the next thing I'd say is that in each case where there's an expert witness, of course, and the two who've requested may not be aware, but there is a practice or a protocol required of them where they have to say what their instructions were or what involvement they've had in anything to do with the projects. There are quite a range of declarations around that they may or may not be comfortable making, but they would need to if they advance themselves as a witness. And the other thing that the chair might want to consider in addressing them is it might also foreclose on other opportunities in the hearing. As a submitter, you get to cross-examine our witnesses and put questions and test things. As a witness, it's not, well, it's up to you, Chair, but certainly it's unconventional for witnesses to question each other. And so it might be that both the two who have requested to be witnesses would find that making submissions based on their expertise, but having an opportunity to question our experts is attractive to them as part of putting their case, and they might be foreclosing on that if they elevate themselves to witnesses. Please, I'm not trying to suggest one way or the other what anyone might want to do. I'm just setting out that there are pros and cons, it seems to us, and we wouldn't want it thought that the submitters need to have to declare that they're a witness just because they've got some expertise and that they wish to present submissions that are based on expert knowledge. We certainly would not be submitting to you that they should get no weight or little weight because they didn't make themselves witnesses. And we see some complications for both of them if they try to call themselves as an expert. So we'll cooperate. If the decision is that those submitters would like to call themselves as experts, all we'd say then is that some documents should be prepared perhaps by the date of expert evidence so we know what the scope is of the matters of expertise that would base any questions, should we have any, would be based on that document in those circumstances, and no doubt that document would otherwise comply with the committee's or the usual panel practice note.
Yes.
So,
thank you, Mr. Townsend, and very helpful for you to run through what you see as the pros and cons of the potential scenarios. I think that as you have rightly described it, there are absolutely potentially pros and cons, and it's good to think them through clearly. So Dr. Murdoch, you've popped your camera back on. Oh, actually, before you do that, are there any other parties who do have any comments before I do come back to Dr. Murdoch and Mr. Frood for your thoughts?
Are we going to find out who the experts are?
I'll talk through that shortly, Dr. Kelly. Thank you. Okay, so Dr. Murdoch, I'll come back to you, and there's no rush to make a decision, to be honest. It's not something that you have to decide today. It might be something you'd like to give some thought to, and the committee could put in place some processes as described by Mr. Townsend in terms of confirming the exchange of information and other things. But I'll just get a sense of what your current thinking is.
Thank you. Just noting that the experts are here to serve the committee. I'd just like you as chair perhaps to respond to the two items raised by Mr. Townsend around the weight of a submission versus an expert witness, and also the independence comments that were made. I was just wondering if you could provide a bit more of the chair's perspective on those items.
Thank you. So in terms of weight, I mean, it is beneficial to the committee to have expert evidence cross-examined in particular, so that we can get a sense if the work is not particularly challenged or is not challenged in a way that undermines a position or in relation to the project. It is something that the committee may be inclined to give greater weight to than evidence that hasn't been, or submission that hasn't been through that process of testing. So the process of cross-examination is essentially a professional process of testing the evidence before the committee. The independence, I understand what Mr. Townsend was talking about. He's raising the point that both yourself and Mr. Frood have an association with the place and the issues and the content that you're presenting to us, but you're correct in saying that the obligation of the expert is to advise the committee to the best of its ability, knowing that you would get cross-examined. So the committee will be mindful of that, but it is something that as an expert you would need to make reassurances through some of that preliminary material, the declarations and involvement and clarification of scope that Mr. Townsend mentioned. So from the committee's perspective, I think we would be happy to hear from you in either capacity. And if you would like to indicate now what you think that may be, but afterwards you change your mind, you can let the planning panel's office know and we can advise the participants in the hearing of that, or if you'd like to. So I would be interested in an indication of what you're thinking now, noting that it could be changed and that we'll put in place the procedures we need to either way.
I am thinking that I'd still like to be heard as an expert witness. I would like the opportunity to reconsider that, particularly when we do hear which expert witnesses Lower Murray Water will be bringing forth on the entomological area.
Okay, thank you. And Mr. Frood.
I am perhaps in a similar position as at this stage feeling expert witness is appropriate, but would like time perhaps to think about that as to what the best option is. And I'm also curious about the capacity to question other expert witnesses, how that occurs as a submitter. Does that mean if I'm present at the hearing, I can kind of put my hand up and ask questions of
as a submitter, that is what occurs, that's right. And I understand the dilemma raised by Mr. Townsend that if you're wearing both hats, it's very unusual, and that there may be other processes that we need to consider putting in place, such as a meeting of experts in advance that might mean that you get to come up with a common statement of agreed views or not that would be circulated to the committee and parties in advance of the hearing, rather than that process of cross-examining as a submitter would generally do. I haven't fully thought that through. It's something that the committee can turn its mind to when we have a clearer understanding of what the preferred approach is from each of the parties. And
I also have another question in relation to revelation of potential prior involvements or what may be perceived as conflicts of interests. Now, I have provided information to DELP, which they may do whatever they choose to do with. Is that the sort of thing that is required for me to reveal?
So it will be your judgment, Mr. Frood, on what you think the committee needs to be aware of. Certainly it's not uncommon for either submitters or witnesses to, in professional capacity, to have shared information with government agencies and other organisations. If think it's material to your position, it would be prudent to make the committee aware of that. So it's really your judgment as to what the relevance is to your expert evidence.
Yeah, I suppose I put in information that's very similar to what I've submitted to you, but then I have absolutely no power or whatever as to what they do with that. So
yes,
Yeah, okay, thank you.
Thank you. So we will note at this stage that is still potential. I expect, and we can cover off on this again if there are any other procedural implications, but the potential that if Dr. Murdoch and Mr. Frood are presenting as experts to have a meeting of witnesses in advance of the hearing may be a way that we can resolve that, and we will need to, I'll come to you in a second, Mr. Townsend, of whether as it does mean that they no longer are presenting just as submitters and they are forfeiting the right to cross-examine the witnesses. I think that is something that both parties should think carefully about whether that's beneficial to the issues you're putting before the committee. Another suggestion, actually, Dr. Murdoch and Mr. Frood, is to have a look at the guidance around giving expert evidence at a planning panel. That might assist, and I'm sure Ms. Selvarage in the planning panel's Victoria office can assist you with a copy of that if you can't find one online. Mr. Townsend, I think you popped your hand up. I'll come back to you.
Only to assist and with the two comments you've just made, but seeing you have come back to me. Firstly, agree that I think it would be practical if the two want to be giving evidence as such that if they're in the conclave, that is a better way to deal with the exchange of ideas between experts than one questioning the other in the hearing. So that would be, we'd suggest a practical way of dealing with that issue. As to the second, you also touched on it for Mr. Frood's, the obligation to disclose is really a declaration made under the practice note, and it is required that it's incumbent on the expert to declare any matter that that is appropriate and should be declared as relevant. So it's not so much a choice of whether you think or not, it's the obligation is really, if it is potentially a relevant matter that should be disclosed, the obligation is to disclose it. I'm sure Mr. Frood would do that, but I'm only making these comments to assist in the judgment that the two would like to make between their options. Thank you.
Thank you, Mr. Townsend. So I think we have covered off on all the issues we need to discuss on that matter. So thank you very much to Dr. Murdoch and Mr. Frood for participating in that and exploring that concept with the committee. It's not one that we deal with all that often. So we'll put you down as submitters, but with the maybe for experts, and that will be confirmed. During this morning's directions hearing, we're going to talk in detail about the timeframes for exchange of expert evidence and other things. So you'll get your head around what those dates are when we do that. I'm going to propose that we take a 15-minute break. We've been sitting for an hour and a half, we still have quite a lot of material to get through, and I think it might be wise just to have a brief break. So if we come back at 11:45, we'll see everybody then. Thank you. Great, thank you very much, everyone. Just checking who we have in the room. So we'll keep moving through our agenda this morning. Dr. Murdoch, I'll come to you in a moment. I can see that you have your hand up. So just before we do completely close off on the issue that we were just discussing, I just wanted to ask a question of the proponent in the context that cross-examination and the process of testing evidence is different to what can be explored by the committee through a conclave process. And it would be the committee's preference that if Mr. Frood and Dr. Murdoch are presenting wearing both hats, so the unusual circumstance of both submitter and expert, whether I suppose in the spirit of ensuring that the committee has informed itself as fully as it can and tested the information before it, would the proponent object to Mr. Frood and Dr. Murdoch being able to cross-examine other witnesses?
No, our comments are all just designed to try and facilitate the process, not to prevent anything.
Thank you, Mr. Townsend, for that clarification and for being so accommodating and flexible in an unusual circumstance. So thank you. I'll take that on note and consider that as we plan for the hearing. I know Mr. Frood is here, and I'll just check that he heard that and is able to consider that. And Dr. Murdoch, I saw your hand up, but now I can't see. Oh, you are still with us. I just wanted to check that you were both. You both heard that exchange.
I certainly have, thank you.
Great, thank you. So is there anything else you wanted to add before we do move on to the next topic? Were you happy to still consider?
Just a point of clarification, and you may have just answered that. You'll be aware that I put in 2 submissions, one exclusively regarding the arid bronze azure butterfly. The second submission was as a landholder, which was a joint submission with my husband. Just confirming that either myself or my husband would be able to ask questions of the expert witnesses as a submitter regarding our landholder issues.
So thank you, Dr. Murdoch. On the basis of the discussion and question and answer that we just had, certainly, and on the understanding that you've submitted twice wearing different hats, I think that that's certainly no issue with that.
Thank you.
Thank you. And also just to note that the timetabling would need to be adjusted accordingly if we do need to allow for cross-examination. So we will have a look at that and make sure that the timetable can accommodate that if necessary. So I'll move on now. The next issue, procedural issue I had, well, the next thing I wanted to mention was, and Mr. Townsend helpfully mentioned this in your introductions, but just commenting that the proponent advised that Lower Murray Water will be representing each of the partner organisations at the hearing. You have already clarified which partner organisations that involve, so I was going to ask you just to confirm, but you have already. The proponent in correspondence with the committee also noted that Parks Victoria has made a separate submission to the committee as the Crown Land Manager of specified parks and reserves affected by the project. So we acknowledge that submission is in a different capacity to that which the proponent is representing Parks Victoria. And the proponent also, to inform parties, the proponent has asked that any specific questions to partner agencies be directed to Lower Murray Water in the first instance so it can coordinate a response. The proponent also indicated it intends to have someone from Mallee CMA present to the committee as part of its opening submissions with regard to environmental water management and project operation. So Mr. Townsend, I just was going to give you the opportunity to speak to the proposed arrangements, if there is anything that you'd like to expand on, or whether there are any timetabling considerations for the committee in light of the Mallee CMA or any other components related to the partner organisations.
Thank you. What you've just described to us all is consistent with the instructions and the approach that's been taken. I should indicate we had written to you, and I know you've still got the letter of the 31st of October 2022 providing that background. We don't object to that being a tabled document.
Thank you. We would do that.
That's so that others can see what your comments were there based on, but you've faithfully described exactly what we had in mind. Perhaps if I take it for the benefit of others a little further so they can see what we'll be suggesting when it comes to timetabling. The intention we have is that we would expect that on the first day, although your attachment 2 in your hearing order, you had us doing an overview and then going to the DELP impact assessment unit, we would have suggested that you start with DELP and then come to us and we can take the rest of the day, as it were. But the intention would be that we would see so much of that day 1 as we got as being very much explanatory and going through matters that we need to elaborate on from the submissions and the whole overall context, and that we would be giving explanatory presentations that we'd set out for you in that letter of the 31st of October, but we can clarify in our letter for you by the, I think it's the December the 1st. So really we'd see that first day and probably well into the second day being quite descriptive, and with these assistance of the partner agencies as necessary, particularly Mallee CMA, in making presentations to you that are quite visual and descriptive, rather than just have the lawyers trying to explain for you the project. So they'd be called really to help me explain the project rather than as expert witnesses as such, but really we would just be sharing the load. So we'd see ourselves doing a fairly descriptive exercise for you that day one into day two. And then we had, at the moment, grouped into 3 groups, expert evidence. Again, by the Thursday of this week, we'll be giving you, in accordance with your pre-directions letter, confirmation around this and the details of experts. But in summary, it's as we have set out in that letter of 31st of October, that there'd be a group 1 where it's really a water or surface water and groundwater experts. The second group, which are the ecologists, flora, fauna and aquatic. And the third group going to Aboriginal cultural heritage and bushfire. We might need to, after today, give some thought to whether we've got the full list or not, or whether the committee agrees with that. But what we estimated, including cross-examination of those, was sort of 2 a day where they're complicated witnesses seems to be a safe, just rule of thumb. But sometimes witnesses take longer and sometimes a little shorter. But based on that being 1, 2, 3, 4, 5, 6, 7 witnesses, we'd got to about 3.5 days. If I can just make this comment now, it might assist you when you're looking at the timetable, because what we in that letter suggested was that our introductions and evidence might take a block of, say, 6 days, depending on how much housekeeping takes up part of day one. If the hearing is to start on the 16th of January, and on the assumption the committee would be sitting 4-day weeks, which are all matters for you, but assuming you were, we noted that if you did 4 days in the week of the 16th, the following week has got the Australia Day holiday on the Thursday, and then you might not sit the Friday and you'd have 3 days. It seemed to us that you could give us that Wednesday as well, so it'd be a 7-day block. We could neatly finish on the 25th, as it were. You'd have your Australia Day weekend and then come back for your submitters. So our 6-day estimate might be a 7, but it seems to me if we had that block, we'd work towards making that work. The only other comment we'd seek for scheduling is that, subject to your site inspection at the end of the hearing, you'll expect from us a comprehensive written reply submission, and we'd suggest, given the technicalities in this matter, that you allow virtually a full day for us at the end of the hearing. So our intention would be the 6-7 day block, really doing the introductions and the evidence, and at the very end, our comprehensive reply document for you, with then also any further work on the EDSs and InkDoc and the like as a description at the end of the case. So I just wanted to give you that as a timing estimate, within which you can then get estimates from the submitters about how long they think they'll need. And I know you'll come back to us about any site inspection or Mildura sittings for later in the hearing. There is a matter I wanted to raise about the key dates for document exchange.
Mr. Townsend, I might come back to you, unless it's something that we need to deal with right now. I might come back to it because I do have it on the list. So thank you. Thank you for that explanation for the benefit of parties who haven't seen that letter. And yes, if we could table that letter, that would be helpful, I think, for parties to understand the proponent's approach and who it's representing. And you have anticipated something that we will discuss shortly, which was the committee is intending to issue directions for the proponent to provide us with some visual material on day one to take us on a visual tour of the site, noting that if a site visit is able to be will be possible it'll be later in the hearing. So certainly that process you've just described of it being quite a descriptive introduction and description of the project is what the committee was hopeful would be the case, and will be issuing directions in relation to that visual material. So that's good, thank you. Dr. Kelly, I can see that you have your hand up. I'm actually going to come to you in a moment. I'd like to just keep moving through a few things that I can cover off fairly quickly, and then I'll come back to you, but I didn't want you to think that I wasn't aware that you had your hand up. So just following on in terms of government agency submissions, as I've noted, the committee's received submissions from the following government agencies. So the Environment Protection Authority, the Victorian Environmental Water Holder, Parks Victoria and DELP Environment, and DELP Environment has requested to be heard. So I'm going to quickly talk through the request for further information. So having undertaken a preliminary review of the EES material and submissions, there are a number of matters that the committee is seeking clarification of or further information from the proponent. The committee has prepared a request for information. So I'm now formally tabling that as part of the hearing process, and it will be uploaded to the Engage Victoria website shortly. So that'll be document 13. So we'll make the letter that you suggested earlier, Mr. Townsend, document 14. The request for further information essentially puts the proponent on notice of some matters. Oh, sorry, I was just going to also mention that the proponent did receive a copy of that earlier this morning, just as a courtesy before today's directions hearing. It essentially puts the proponent on notice of some matters that the committee intends to explore through the hearing process. The information is sought for clarification and is sought without prejudice to the final recommendations of the committee. So parties should not assume that the issues raised in the RFI are the only issues of interest to the committee, or that the committee necessarily has any concerns about those issues. We'll be seeking further information as necessary throughout the course of the committee process, including exploring issues with experts and submitters at the hearing. So the committee is left open to the proponent as to how it responds to the RFI, whether it does through submissions, evidence, or written, separate written response in the form of a technical note or a combination. I'd just like to note that given the relatively short time frame for the committee to prepare the RFI and the extensive range of material in the EES, it's likely that some of the committee's questions will raise matters that are addressed in the EES. In those situations, the proponent will only need to direct the committee to the relevant document. So we're not asking for further information if it is clearly located in the EES. Mr. Townsend, is there anything regarding the RFI that you would like to raise at this stage?
No, we thank you for it. We'll take it under consideration in the sense, as you set out in the RFI, that some responses will be dealt with in our first submission, some in technical notes, some through expert witnesses, and some by directing you to the EES. We'll go through that and let you know should anything arise or if there's any clarification we seek. But for present purposes, thank you, and we will attend to it.
Thank you, Mr. Townsend. We will issue a direction for the proponent to clearly explain or to tabulate how each of the queries has been responded throughout the submissions. In relation to traditional owner involvement in the process, as mentioned earlier, the committee must review and consider for each assessment package any known views the registered Aboriginal parties or traditional owner groups, or to seek the views of those groups if they are not already known. And I noted that both projects are located in areas where RAPs have not been appointed. The committee has sought to ensure known traditional owner groups and interested parties are aware of its process, and to extend an invitation for those groups to participate in the committee process. Pursuant to its powers to inform itself however it sees fit, the committee wrote to a number of organisations seeking advice on relevant traditional owner groups and interested parties and the associated contact details. So the organisations contacted included the Victorian Aboriginal Heritage Council, First Peoples State Relations, DELP Land Services and First Peoples Group, and also the proponent. The proponent advised that Mallee CMA has been the lead organisation relating to traditional owner engagement for the projects, and the committee subsequently wrote to Mallee CMA seeking advice on groups and contact details. Also seeking further information on the engagement process that had been undertaken in relation to the projects to date. So all of that correspondence has been tabled and is uploaded to the Engage Victoria website as documents 2 to 9 and also document 11. So if parties are interested, you can view that correspondence there. In its response to the committee, Mallee CMA on the 24th of November confirmed that it had primary responsibility for engaging traditional owners and interested parties through the development of the projects, and it directed the committee to relevant EES documents to understand its engagement process. So Mallee CMA did not consider it appropriate to provide contact details for the traditional owner or interested party groups to the committee, but offered to assist the committee by providing information about the committee process to those groups with an invitation for them to get in touch with the committee if they'd like to participate in the process. The Mallee CMA indicated it would do so as promptly as practicable, but that a time frame could not be indicated. Mallee CMA advised it will update the committee on its progress. So the committee appreciates the Mallee CMA assisting the committee as offered, and the committee will issue a direction that Mallee CMA via the proponent provide an update on the process of contacting relevant groups. And for this to be provided as part of the, I've got a date in the directions hearing. I won't touch on what that is now, but that's something that we'll be issuing a direction regarding for Mallee to provide that update to the committee. The committee has also requested some further information about traditional owner engagement and response to those issues in the request for further information that we just discussed. So I'm moving on now to recording the hearing. So the committee intends to direct the proponent to record the hearing. It will be an audio recording only. The committee is of the view that recording the whole proceeding will assist with transparency and assist interested parties wishing to follow the proceedings, and will help if we're unable to attend particular sessions for any reason. Arrangements for recording will be discussed when we discuss the hearing arrangements. So I've just got one further procedural matter to run through before we discuss the hearing arrangements. I will run through this and then I'll come to you, Dr. Kelly, noting that your hand is still raised. So I'll be with you shortly. The committee is proposing, so in terms of site inspection and visual material, which we touched on briefly just before, the committee is proposing to undertake a site visit during the hearing, if this is possible, given the current flooding situation. We plan on visiting key parts of the project area and key locations in the surrounding area. So the proponent has advised it is best to allow 2 days. Due to committee availability and scheduling, the committee proposes to schedule the site visit in the week commencing the 6th of February, but for this to be confirmed closer to the time with consideration of issues relating to issues in safety. So after today, we'll circulate a list of the locations that we propose to include in our site inspections and to invite parties to nominate additional locations to be included. The committee will issue direction for the proponent to provide a draft site inspection itinerary by Tuesday, the 13th of December. I'll just run through as the summary list of of sites that the committee has an interest in viewing. And as I mentioned, they'll be provided in the correspondence following today's directions hearing. So firstly, sites of key infrastructure and maximum inundation areas, including sites for the large regulators, sites for the 2 culverts, example sites for smaller infrastructure, sites for permanent hard stands, tracks or roads that are likely to be impacted by construction traffic, possible borrow pits, any sites previously used to dispose of waste. The committee would also like to see examples of sites where large trees are proposed for removal, sites where the ecological vegetation classes are expected to benefit from or be detrimentally affected by the project, so either or, and areas of it's not a word I get to say every day, terrestrialisation of EVCs, and sites affected by salinisation. We have some listed specific locations such as Belsar Island, Nakuya Creek, Boniari Creek, Lake Powell, Lake Carpool and Euston Weir. Also Hattah Lakes North, Chalka Creek, habitat for the Mildura butterfly, and possibly Rakajilim, and apologies again if I'm mispronouncing. We'd also be interested to see sites or areas of cultural heritage significance in the above areas if it's considered appropriate by the traditional owners. Are there any parties who would like to, or we will, as I said, we'll provide an opportunity for parties to nominate additional locations, and we'll issue directions and the time frame associated with that. The committee proposes the site visit would be accompanied, so that is with interested parties or parties to the hearing attending if they are interested, but there may be limits on the number of people able to attend due to logistical constraints. The committee proposes that a final decision regarding whether the site inspection is possible be made by the proponent by Monday the 9th of January. And if a site inspection is not possible, an adjusted timetable would be issued before the hearing commences. We will also issue a direction asking parties to indicate their intention to participate in the site visit if it does go ahead. So given that the site visit may not be possible, the committee will ask the proponent to prepare and collate visual materials for presentation during the hearing. This may be a combination of photos, videos and/or drone footage, and may be drawn from existing material where appropriate. Visual material should be suitably annotated to assist the committee in understanding the key features of the relevant locations and to get an understanding of the context and elements of the landscape. As we discussed briefly before, directions will be issued asking the proponent to present that material on day one and as relevant throughout the proponent's submissions. The Planning Panel's office will continue to liaise directly with the proponent in relation to that over the coming weeks. And Mr. Townsend, I'm just going to ask if there's anything that you need to raise or bring to the committee's attention in relation to potential site visit or any of the issues I was just mentioning.
No, that's perfectly clear, and we'll endeavour to be able to predict by the 9th of January the situation. As I understand it, at our client's end, they're coordinating the practicalities of vehicles and those things, and I imagine there's somewhere between Panels Victoria and our client liaison around that issue. But given that the hearing we'll be seeing you in the week or two ahead, a number of those matters can no doubt be resolved at the hearing itself.
Thank you, Mr. Townsend. So before we do talk about the hearing arrangements, Dr. Kelly, I'll come to you now for your question. And apologies for getting midway. I'm just conscious of the time. We've got a lot to get through, and I thought I might just continue to get through all those matters. So over to you.
I'm very happy that you waited. There's no problem at all. I had a question when you listed the acts that the committee will be considering that I didn't hear you mention the National Parks Act.
I may not have. I know that yes, it may not have been in my summary list, Dr. Kelly.
So is that going to be?
It will certainly, well, to the extent that the committee, that it's presented any issues relating to that, I know it will be discussed and aired at the hearing. So it's not off the table, any concerns that submitters have in relation to that.
Mm-hmm.
Obviously, the committee's scope is not to make decisions under that. Yeah.
The other thing was, is there any support for community members to participate in this process? Because you know, 3 to 4 weeks of hearings, site visits, considering that the proponent and such are all.
So, Dr. Kelly, were there specific things that you have thought of that you or that you would suggest that would be of assistance?
Is there?
Yes.
I can't think of anything, but I just am aware that some people participating in this are public servants and others are community members, volunteers. So it just to give fairness, and I would not like to think that some people can't participate fully because of financial reasons.
Okay. So, Dr. Kelly, one of the reasons that we've decided to record the hearings is so that they're available out of the hearing time as well, so that any interested party or community member can listen to what's occurred, particularly if they're not able to be present throughout the whole hearing. We'll discuss, when we discuss hearing arrangements in a moment, we'll talk about the format of the hearing. So whether it is using the sort of technology that we are today, or whether it's a combination of in-person or other, there may, if there were specific needs of a party in terms of participating in the hearing, we'd be happy to talk about that. And there may be some options to help with accommodating with venues and other things that we're about to discuss. So
yeah, so for instance, Swan Hill is 2 hours from Mildura, 4 hours from Swan Hill.
Yes.
Yep, and just lastly, when you talked about the Mallee CMA giving you details about traditional owner engagement, it sounded like you were giving the Mallee CMA an extension on that.
No, so it's not part of the submission. So the submissions have specific timeframes. They have to be provided to the committee within a particular timeframe. From this point onwards, we can ask the proponent and other organisations for further information or assistance, and that's more of a progressive process of requesting further information. So we are proactively seeking that information, and we have decided to issue a time frame for the committee to be updated.
Yep, thank you. That's all I have.
No problems. Thank you. Okay, so we're now going to talk about the hearing arrangements. So in our letter to submitters of the 16th of November, we advise that the hearing will commence in the week beginning the 16th of January and is likely to run for 3 to 4 weeks. So today we will finalise the dates, if we can, for the main hearing, discuss arrangements associated with that. I understand that there's some uncertainty around a few things to do with the site visit, and we'll discuss those as well, or the implications for the hearing. In terms of requests to be heard, the committee has received 13 requests to be heard. That includes the proponent, so 12 requests to be heard plus the proponent. And the committee has also asked the DELP Impact Assessment Unit to attend on day 1, which Mr. Townsend mentioned a little earlier. The Impact Assessment Unit will present an overview of the EES process leading up to the referral of EES Central to the committee. So I'm just going to read through the request to be heard and what people have asked for, and then I will ask if anybody needs to clarify or change your request. So Lower Murray Water, the proponent, we've already heard, so 6 days for main submissions plus 1 day of closing. The Victorian National Parks Association has requested half a day. There might be something we need to clarify, whether that accommodates the witnesses that you are proposing to call. So you are intending to call witnesses. Oh, and apologies, I didn't mention, but you already know the proponent is proposing to call witnesses. The DELP Environment, Department of Environment, Land, Water and Planning, it has requested 30 minutes. Matthew Koloff and Jamie Pittock from the Fenner School of Environment and Society at ANU have requested 30 minutes. Environment Victoria, represented by Ellen Mabry, Environmental Justice Australia, who is with us today, has put in a request for half a day. The Friends of Naya Vinifera Park has requested 15 minutes. Mallee Conservation, so Dr. Fiona Murdoch and Phil Murdoch have requested 15 minutes, and also the separate submission from Dr. Murdoch, she had requested 30 minutes. And I know we've already discussed the changes that may be required or extended time if she presents as an expert. Brett Ainsworth has requested 5 minutes. We will likely make the minimum submission time in the timetable 10, given the number of submitters, but we'll see. So Brett Ainsworth, 5 to 10 minutes. Doug Fruit has requested 40 minutes. Peter Thornton, 30 minutes. Donald McLeod has asked for 5, and Peter Kelly has asked for 20 minutes. Are there any changes that I need to note in terms of the request for time, or any party's indication that they may be calling evidence that haven't previously indicated that? Mr. Decker, I'll come to you first.
Thank you, Chair. Delp initially asked for 30 minutes to be heard. That was myself when I loaded our submission on the Engage Victoria website. And my thinking at the time was really around just making ourselves available to assist the committee. As it currently stands, I don't propose to expand on anything within our written submission. However, there's a portion within our submission that deals with overall improvement to biodiversity and the results of some expert elicitation that is currently being undertaken, which has not yet been fully tabled. I'm presuming that, and it might be a bold presumption, that you may want some commentary from the department around the results of the expert elicitation and the overall improvement to biodiversity proposal. However, you know, I'm a little bit guided on what the committee would like around that. I'm starting to think that we might not actually need that formal 30 minutes scheduled into the hearing, and that, you know, I will be present throughout the hearing and be available to take any questions on notice around that we could then look into and get back to you on. Another point is that at this stage, we're not proposing to have any expert witnesses, but I'm not the technical expert in a number of matters that we have submitted on, like bushfire or threatened species and native vegetation policy, etc. In my experience of the handful of panels that I have attended, we don't tend to provide expert witnesses on those matters. Rather, that, you know, if the committee does have a question, that, you know, I could take them on notice, get in contact with those potential technical experts or advocates potentially, and bring them in and, or, you know, provide a response myself or in writing on behalf of those people. So I think in summary, I'm just trying to make sure that we are being flexible and providing presence that's of greatest assistance to the committee and the hearing.
Thank you, Mr. Decker. That's clear. I think my feeling is that if you're not proposing to actually make submission to us, but we're wanting to be available to respond to questions, we would take you out of the timetable for now, and we can certainly write to you if we have anything where we would like to seek your views. I suppose the pros and cons of our discussion today, that would put you in a situation of not being able to present or respond to any further information that comes up throughout the hearing process, and the expert elicitation report that you just mentioned, that the committee will be asking to be circulated if it's able to be, or if it's ready to be. So we could go either way. We could leave you in the timetable and you could advise closer to the time if you feel that that's not required. And if you do choose to withdraw from the actual presentation, the hearing process, we can consider if we had any questions we wanted to put to you.
My current thinking is that we probably don't need that scheduled 30 minutes, and I'll make sure that I'm in attendance and available for any matters that require some attention.
Okay, so at this stage we'll remove you from the hearing timetable, but we'll seek your views if the committee thinks that it needs to.
Thank you.
Thank you. Dr. Kelly.
Could I just ask that we be given more time than 15 minutes? I don't actually remember ticking that box, but I probably did. I think 30 minutes would be more suitable. And could I ask that we submit to you which of our members makes that submission at a later date?
Yes, that's totally fine. Thank you.
Thank you.
So we'll put your name in as being represented by you at this stage, but we can put it to be confirmed after that if you would like. Or you're welcome to change and advise us before the hearing. It's not a problem. Great, thank you. Anyone else needing to speak to your request to be heard? No, okay. So Mr. Townsend's already covered off on the areas of where you're intending to call expert witnesses. So I won't recap on that. I might just now come to the Victorian National Parks Association to continue the discussion that started a little earlier as well. Was there anything, just to ask, is there anything else that the committee needs to be aware of at this stage, Mr. Crook, in relation to your expert evidence?
No, nothing further to what I said before.
Okay, and at this stage you're intending to call 2 experts?
Yes.
And are you comfortable that the half-day allocation is adequate for that, or do you think that there may be a need for a longer allocation of time?
No, I think half a day will be fine.
Okay, and you're taking into consideration the time needed for cross-examination?
Yes. Yep.
And your primary submission as well?
Yes. Yep.
Okay, thank you.
Thank you.
Could you just confirm for me the areas that the expert witnesses, I know that parties need to formally advise by Thursday this week,
yep,
of whether you've got who the experts are, but could you just please confirm the areas again?
Wetland ecology and general ecology, and concerns under the National Parks Act and land tenure appropriateness of these developments.
Yep, sure. And you're not able to advise us who that is at this stage?
Not yet, sorry.
Okay, thank you. Thank you, Mr. Crook.
Thank you.
So as I just mentioned, the committee will issue a direction for all parties to confirm the details of their witnesses by Thursday this week. And just a general note that if parties find that they cannot complete their submissions within the prescribed time, you may request leave from the committee to present any additional written material, and we will consider all the material before us, the written material and the material you present to us at the hearing. And I just ask again, if any, before the end of today's directions hearing, if you are rethinking the time allocation required, if you could raise that today, that would be very helpful. It's difficult to start rearranging the timetable once we've set it. So if you have any second thoughts before the end of today's directions hearing, please, please let me know if you think that the time needs to be different. Okay. So in terms of the order of presentation, as Mr. Townsend mentioned earlier, that was in the letter sent to all parties advising them of this directions hearing. I won't run through the list, but I note Mr. Townsend's suggestion to have the impact assessment unit as an introductory presenter, and we're happy to accommodate that. That sounds like a very logical thing to do. And just to explain broadly, the reason that we hear from parties in the order, that order in the letter, is so that we can fully understand the proposal at the outset before we hear the detailed submissions on the matter. So it helps the committee to better understand and appreciate the submissions. The closing submissions, as mentioned by Mr. Townsend as well, we understand the proponent will need a day. The purpose of closing submissions is to give the proponent the opportunity to respond to any new matters that have arisen during the hearing after it has presented its case. There are occasions where committees can provide other major parties an opportunity to provide a closing submission. I'll just pause for a moment and see whether anybody feels that they might be in that situation. I'll assume that the proponent's closing will be adequate with this matter. So we'll move to talk about dates. So based on the request to be heard so far and subject to any adjustments that might need to be made, we think we will need about 9 days to complete the hearing if we allocate the full amount of time requested by each party. So it might be 9 to 10 days. We are planning to sit for 3 to 4 days a week, noting that there is a public holiday, as already mentioned, in one of the weeks, and we were going to propose to commence the hearing on Tuesday, the 17th of January. The order of presentations might vary slightly to accommodate availability. Essentially, the timetable would be structured to hear from the proponent in weeks 1 and 2, and the submitters in week 3 and 4, and week 4 for the site visit and closing submissions. The reserve time will be allocated to provide some flexibility in the timetable if needed. So we will prepare a timetable for the hearing based on the information provided on the request to be heard forms and the discussion that we've had today. We'll send a copy of the timetable to everyone who's indicated that they wish to be heard or that they want to receive a copy of the timetable. As discussed earlier, depending on whether the site inspection is possible, the timetable will be adjusted and confirmed before the hearing commences, unless the proponent advises otherwise and considers that it might be prudent to wait to make that decision about the site visit until later in the hearing process. Regarding the hearing format, we did ask submitters to indicate on the cover sheet whether they would prefer to appear in person, online, or using a hybrid format. So a hybrid format is a combination of in-person and online. The proponent has indicated that it would prefer to be heard online, and a number of community submitters have requested to be heard in person. If there are any in-person days, the committee would require them to be run as a hybrid. So we do provide the technology or have the technology provided to allow people to participate online. So the committee is proposing the first 2 weeks of the hearing be held online. It may be possible to conduct some days in person in Mildura if the committee undertakes a site visit in week 4. We understand the proponent has made some inquiries about the availability of a suitable venue for a hybrid hearing in Mildura. If we do hear from community submitters in person in week 4, the final closing submissions may need to be on Monday, the 13th of Feb. If the site visit doesn't proceed during week 4, the hearing may be able to be held in either as in-person hearing from the Planning Panel's Victoria office in Melbourne in week 3, with submitters having the option of appearing online. So we would only take that option if there were parties who wanted to appear in person in Melbourne. And it would mean, obviously, if someone's wanting to, if we're not coming to Mildura for the site visit, the online option, the hybrid option would be based in Melbourne. Whether or not we conduct some sessions in person, we will need to conduct a substantial portion of the hearing online. And we will ask the proponent's assistance to set up the online hearing and provide technical support, such as it has done today. So thank you for that. Just a reminder that the committee is required to conduct its hearings in public. So any in-person sessions would need to be set up in a COVID-safe environment. But an online link would be published on the Engage Victoria website, so interested members of the public are able to log in and observe the hearing. So the committee is interested to know, I know there's a few pieces of the puzzle there that we need to somehow get to land, including considerations around other commitments from the committee that may influence scheduling. But I'm particularly interested to hear from from participants today, whether you have a preference for an in-person hearing, and if so, why? If you could just explain the reasons and also the preferred location. So if you would either consider Melbourne if it was a hybrid, or if it would have to be in Mildura or somewhere in that vicinity. I understand that Mildura is not very close to the sites, as Dr. Kelly mentioned. There's still travel time up north as well. So I will just ask parties now for their views, and I'll come to you, Mr. Townsend, first, and then I'll come back to you after we've heard from others as well. But just to confirm the proponent's position on its preferred format of the hearing.
Thank you. We had taken the view that in this case, substantially online hearings would suit a number of the parties, and we understood that, I think, from some previous consultation as well. But for our own part, given the number of agencies and the sheer spread of our own people, we think it happens to be a case where online will work better. Having said that, we'd also anticipated that if we had those few days at Mildura, if that was an opportunity for submitters who'd rather be heard in Mildura, we would certainly expect that to be face-to-face, and as you've indicated, our client can make a venue available. So subject to any other way we can assist you, or whether you would prefer us face-to-face, our preference is substantially online.
Great, thank you, Mr. Townsend. Dr. Kelly, I'm assuming your hand is up to speak. No. Are there any parties here who would like to express your preference for the hearing format? And perhaps particularly in a targeted sense, if there is a particular reason that we need to run it as a hybrid at any stage, or if you would be happy to accommodate it being online. Ms. Mabry.
Thank you, Chair. Just to note, I think in our submission we had selected in person, but we're happy to accommodate whatever works for the committee, and particularly would not wish for us to appear in person if it prevented others in the local area from appearing in person in Mildura.
Thank you. Any other parties with a view? You did
I'm open to whatever happens. We're pretty used to having to go to Melbourne for such things. It would be lovely to have something local, but totally understand the need for online and other things. So, yeah.
And you'd be happy to participate online, Dr. Kelly?
I don't really like it, but it seems to be the way of the world now.
Thank you. Okay, so we, as I mentioned earlier, we'll see, get to the point we have a decision about whether the site visit's going to proceed, and plan for potentially, given the number of requests to be heard in person by parties who potentially not with us today, we can follow up with them to see whether actually having a hybrid meeting for a day or two to hear more from those community submitters in Mildura if we are present there. Otherwise, we might look to convert to a fully online hearing if we don't not able to travel to Mildura for a site visit. Okay, any other thoughts on that before I move on? We will look to condense the timetable somewhat as well if we have scope to do that when we're clear on people's availability and the site visit. Okay, I'll continue. So in terms of the committee, I just wanted to bring to parties' attention as well. The committee's terms of reference allows it to sit with a quorum of 2 members, one of whom must be the chair or a co-chair to the Standing Inquiry and Advisory Committee. So,
I didn't realise.
and I'll just mention that we do have a deputy chair, Michael Kirsch, member Kirsch, sitting with us as well. So at this stage, I wanted to flag with parties that we may not sit as a full committee every day of the hearing, depending on the evidence being presented and the nature of issues raised by submitters presenting on any given day. We will make a decision about which committee members will be present, certainly matching up areas of expertise and experience. I've already touched on the witnesses being with parties required to provide confirmation of expert witnesses by Thursday, the 1st of December. I've got here, we'll ask parties to indicate what witnesses they intend to call on the days. I think that only relates to the proponent scheduling. So we'll ask that if the proponent could advise us its indicative order of witnesses by Wednesday, the 21st of December. And if there are any changes for that to be advised, the committee to be advised as early as possible. I certainly understand that community members and all parties schedule their availability, and also the committee around who may be appearing at the hearing on a particular day. So the earlier we can get that advice, the better. There will be some information provided in the directions letter following today's hearing that talks through the process and explains the process for making a submission at the hearing. So I'd just like to emphasise that any material you want the committee to consider must be provided at the hearing or through the hearing process. Also, a reminder that submissions are public documents, so please don't include any personal information that you do not want made public. So you can present your submissions at the hearing orally or in writing. This stage, I understand all parties will be attending, but it is an option to present the material in writing, and there'll be directions issued to explain how that can occur. So you may present additional information that expands on your original submission. There's no need to provide additional information unless you particularly need to. There's also an option of just reading out your original submission or expanding on it verbally. So when you're making your submission, please remember that you're making your submission to members of the committee and that you shouldn't feel as though you need to address the proponent. Sometimes people get nervous presenting to the committee if it's not something that you have experience with. Please try to remember that we often hear from people who are not familiar with these types of assessment processes, and part of our role is to hear from submitters and to get an understanding of how the proposal we're considering may affect them. So to ask everybody to make sure that you are in attendance at least 15 minutes before your scheduled start time. And as we have today, to please use your first and last names when we're for the Zoom or other platform to make sure we can identify you. If you're not presenting any further information, you don't need to pre-circulate your submission because we already have it and it is available to all parties on the Engage Vic website. So Zoom does have screen sharing functions. They're quite simple to use and will help or allow people to present information from their own computers or device. So when you log into the hearing, you should make sure that you have any documents that you're wanting to share ready and to make sure that the screen sharing goes as smoothly as possible. If you have any questions about that, please contact the Planning Panel's office. We will ask the proponent to provide technical assistance to support submitters present as well, similar to today. So I'm just aware of the time. I'd like to, I know we've been going for another hour and I probably have a little bit to get through still. I might go through another couple of items. I'd just like to, and it's close to 1 o'clock, I'd like to get a sense of whether people would like to have a half-hour break shortly. And Mr. Townsend, I'll ask you if you'd be happy to, if you'd like to do that rather than continuing on. It might be that we finish at 1:30 if we don't have a break now.
Well, for our part, we're happy to push on. I've got a couple of scheduling items to raise and a comment on the timetable, but subject to any questions you have, we've only got a few minutes.
Okay. Well, maybe we will, I might get through the next couple of items. We might just take a 5-minute leg stretch break and then we'll come back and finish so that we get done and have a proper break at our lunch rather than extending the time of the directions hearing. And Dr. Kelly, I'm just going to check, have you got your virtual hand up because you have a question, or is it just up?
I just had a question. Yep.
Yes, I will come to you now for that.
The question is about traditional owner engagement. So just thinking about, there should be some consideration of ability for traditional owner people to attend the hearing or participate, and that should be considered when location is considered. And also just wanting to clarify around the committee membership and any traditional owner representation on the committee or expertise in cultural heritage.
Thank you, Dr. Kelly. Yeah, so as I mentioned earlier, the committee is very mindful of its terms of reference and the need to understand whether the views of traditional owners have been considered through preparation of the project, which we understand through the proponent and the materials submitted that they have been. And we are seeking to, we've put in a request for further information to fully understand the process that's been undertaken by the proponent, and also Mellie CMA, as I mentioned, extending an invitation to their contacts to ensure they're aware of this process. So the committee will deal with any requests that come in from any of the traditional owner or interested party groups. Member Ham is here with cultural heritage background and expertise. I don't know, Member Ham, if you'd like to just comment briefly on you've mentioned already, but if you'd just like to very briefly expand on your expertise in that area.
Yeah, as I said, I was involved in the establishment of or oversaw the establishment of the Aboriginal Heritage Act, Victorian, and the Traditional Owner Settlement Act. So I'm probably more au fait than most with their details and how they work. Importantly, to your question, Dr. Kelly, I am a Yorta man. My country is in the central Victorian part of the state, further up the Murray. So the Planning Panels Victoria specifically sought me out for making sure that I was available for this hearing for exactly the reasons that you've raised. So thank you for raising that.
Thank you. It's been a long meeting, and I had forgotten that I had seen you there. That's excellent. Just noting that Friends of Naivanifra Park have always had Wadi representation on our committee, and that we would be pushing that those voices are heard strongly. Thank you.
Thank you, Dr. Kelly and Member Ham. So I'll just keep moving through the final items that we need to cover off on. As I said, I'll just cover off on a couple more, and then we'll have a quick break, and then we'll finish up. So in terms of circulating information, we will ask the proponent to set up a freely accessible document sharing platform, such as Google Drive, that parties can access to view circulated documents and upload material that they want to present at the hearing, as will be explained in the directions. So documents must be circulated by parties by uploading them to the online sharing platform, and parties must be notified as soon as practicable by email after the material is uploaded. That's to ensure that people know that information's been circulated and to know to have a look at the document sharing platform. A distribution list will be prepared that parties can use to notify the committee and other parties when they upload information. All hearing-related documents will be accessible via the document sharing platform, and when the material has been formally tabled and presented at the hearing, it will also be put on the Engage Victoria website. Parties must not record, keep, distribute or publish contact details of any other party, or use those contact details for any material that they circulate as part of the committee process for any purpose other than for the hearing. So I will talk through just finally about recording the hearing, and then we'll break for 5 and we'll come back and talk about the proposed directions. So clauses 45 and 46 of the committee's terms of reference relate to recording the proceedings. So the committee intends to direct the proponent to do this. And as I mentioned, it will be an audio recording only. The recordings will be uploaded to the Engage Victoria website, and we need the recordings to be provided by the proponent in a format that would enable them to be uploaded. Parties will be directed to use any recording only for the purposes of this committee process and not to republish or further distribute the recording. The committee cannot, however, guarantee that a third party will not produce an unauthorised recording or to use a recording for an unauthorised purpose. Parties must not make their own recordings of any part of the hearing by any means without permission from the committee. Okay, so we'll take a 5-minute break and we'll come back and finish the directions hearing by running through the directions that the committee proposes to issue. So we'll see everybody, it's 12:47. We'll make it 12:53 just so that we've got just over 5 minutes. We'll see you back here in a moment. Thank you. Great, thank you very much, everyone. Welcome back. Should be the last leg of our directions hearing, so we'll keep moving through and see if we can finish up in the next 20 or 30 minutes or so. I'll now talk through the proposed directions. So the letter advising parties of today's directions hearing included a list of proposed key dates for the exchange of information in the lead up to the hearing. So in addition to those key dates, the committee has added a few, and I'll just mention those. So by the 13th of December for the proponent to provide some information and documents requested, so it's separate to the RFI. By Wednesday, the 14th of December for the Mallee CMA to provide an update on the process of contacting traditional owner or interested party groups. And as I mentioned earlier, via the proponent. By Wednesday, the 21st of December for the proponent to provide an indicative order of witnesses. And as we've discussed, the proponent to let us know by the 9th of January to confirm if the site visit can proceed. Parties are aware that if they're intending to call a witness, they need to do so. Sorry, I feel like I may be just repeating myself there, but by the 1st of December, we are proposing to direct staggered evidence. So the proponent's evidence is due on Thursday, the 15th of December, and other parties' evidence is due on the following Monday, the 19th of December. The reason that we direct expert evidence to be circulated before the hearing is to allow the committee and the parties to read the evidence before it's presented. If expert meetings are required, so the conclaves that we mentioned earlier, we'll be directing that they occur in the week of the 9th of January after the expert witness statements have been circulated and prior to the submission of expert meeting reports. And the meeting reports are required by Monday, the 16th of January. We will include detailed directions about the conduct of expert meetings and the preparation of expert meeting reports in our written directions. So I just would pause here for a moment and ask the proponent or any other party intending to call a witness if there's anything relating to a meeting of experts or the conclaves that you would like to discuss or touch on today, and whether you think there'd be benefit or not. We obviously don't quite know what we're dealing with, so it may not be a question that can be answered at this stage.
Yes, we don't have anything at this stage. I think it remains to be seen when the evidence is filed. We do have comments about the directions generally, but when you give me a chance. But.
Yes, thank you. I'll come back to you, Mr. Townsend. And I think that, yes, we will, on the understanding that we don't know yet exactly who the experts are, that we will allow for that in the way, either issuing directions that accommodate that or issuing further directions when we have a better understanding of the witnesses. In terms of evidence in chief, so when a witness presents their evidence, it's called evidence in chief. They'll only need to summarise the key points. So witnesses will be directed to limit their evidence in chief to 30 minutes, except with the leave of the committee if there is a request for there to be an extended time. If a witness wants to present a summary of their evidence in the form of a PowerPoint or summary document, they can do that as part of the evidence in chief. Any PowerPoints or summaries will need to be circulated the day before the witness presents. Summaries should be restricted to a summary of the witness's evidence statement and should not introduce any new material. In relation to cross-examination, any party is able to cross-examine an expert witness, and some of our submitters, some of the parties may wish to cross-examine the proponent's witnesses. Many of you may never have cross-examined a witness before, so I will briefly explain what it involves. If you want to cross-examine a witness, you must be present for the whole of the evidence of the witness. When you cross-examine, you must put questions to the witness, and it might be questions about how the witness formed a particular view, what assumptions the witness based their opinions on, or how they verified any facts. So cross-examination is not an opportunity to argue with the witness. We respect that submitters may have a different view. If it is simply a matter of a difference of opinion, you can explain that to us when you make your submissions. If you think, however, that the witness has it wrong, for example, some of the assumptions underpinning their work are incorrect, that is a matter that you can ask the witness questions about. Cross-examination must always be respectful and productive, and it must be about matters that are before the committee. So we will issue some directions relating to the process of cross-examination. We won't allow witnesses to be badgered or for repeat questions to be asked. If we do have any concerns about the direction of the cross-examination, we may intervene or ask where the cross-examination is going. So I'll just pause and ask if there are any questions there before I run through the directions proposed for the proponent.
I had a question about what the term conclave means in this tech context.
So it's a meeting of the experts where they come together and discuss their points of view, and they would generally produce a statement that actually would document what's in agreement and what's not in agreement, so that it can help the committee to focus on the issues that are unresolved or issues of concern. Thank you. Okay, so regarding directions for the proponent, we will direct the proponent to prepare a Part A submission that will be circulated before the hearing and a Part B submission that will be presented at the hearing, with the written Part B to be circulated the day before it's presented. The Part A submission should include background information that assists the committee and the parties to understand the rationale for the project and the strategic and policy context. It should include a broad and high-level summary of the matters addressed in chapters 1 to 7 of the EES that describes the project and the rationale and the design process. It should produce a summary. It should include a summary of the strategic and policy context, a broad, high-level summary of the key issues raised in submissions, any changes the proponent proposes to make to the project documentation, including the environmental delivery standards or the draft planning scheme amendment. Any other strategic material that the proponent intends to rely on in support of the project that hasn't yet been provided, or that it might be of assistance to the committee in its considerations. So the Part A submission should be taken by the proponent as read on day one, but to allow some time for questions. The Part B submission is to address the issues in detail, including the proponent's response to the issues raised in submissions and evidence, any further adjustments to the project documentation in response to the submissions and evidence. At this point, we will ask for a table that cross-references the proponent's responses to the committee's RFI or further RFIs if they are issued through the process, and the proponent's final position on the project. I know the proponent will be aware, but there's no need to repeat any of the information from Part A in the Part B submission unless something has changed. In terms of information to be provided, the committee will issue a direction for the proponent to provide some documents and information. Generally, the committee has asked for a copy or link to the relevant document. I won't run through all of they're a bit detailed because they've come out of the material that the committee's reviewed in the EES, but I did want to just raise a request relating to mapping, just to flag this with the proponent and provide an opportunity for comment at this stage. I'll run through what is proposed to be requested, but I'd like to note that the committee assumes this information may be available to the committee through some of the other documents and may be available to the committee but hasn't been presented. Sorry, it may be available to the proponent but hasn't been presented to the committee or may not have been collated in this form. So if there are any concerns with the request for the mapping information in terms of the resource requirements, the committee is happy to hear that. And also if the information is not readily available, we'd be happy to hear. So I'm just going to read, this will obviously come out in the directions, but I'll just read through the request to provide a map or maps for both projects showing the following in either hard copy or electronic. All of the designated waterways in the project areas, including name labels, existing water infrastructure, including the AHD level elevations of full supply level where relevant, the proposed new infrastructure, including AHD elevation of full supply level and key operating levels where relevant, arrows indicating flow directions, an indication of how the infrastructure is intended to operate. For example, arrows to indicate whether structures such as regulators and pipelines are intended to operate in a single direction or bidirectionally. Existing ground levels, for example, the elevation contours, and aerial imagery base map. So Mr. Townsend, I'm not sure if that's anything you'd like to comment on now, or you'd like to just respond to that towards the end of the directions hearing, or maybe take it.
Look, I've got a few, I'm just waiting for when you let me have a say about the submissions and the documents and the timetable.
Yes, it is coming. Oh, so you'd still like to comment on the timetable specifically?
Yes, we've got a few matters on directions and timetable.
Yes.
I can do them all in one go. Well, you let me know when, but as to that, look, we'll do what if there's any question on those specific matters that you seek in terms of mapping, we'll let you know, but we'll do our best on the basis.
Okay. Thank you. Yes, if you could, in the context of my introductory remarks, if you could just please let us know if there are any concerns with providing that material. I've only got a couple of other things to cover off, and then I was going to open up the floor for any other matters that need to be discussed, and I will come to you, Mr. Townsend, at that point. The committee will just direct the proponent to circulate day one versions of the draft planning scheme amendment, including the proposed incorporated document and the EMF, including the environmental delivery standards, prior to the start of the hearing. Day one versions should be tracked against the exhibited versions. They should show any changes proposed in response to the issues raised in submissions or evidence, and should be circulated by 12 on Thursday, the 12th of January. In terms of information available at the hearing, the proponent should ensure the following information is available and able to be screen shared. The latest aerial photography of the project area and surrounds, and access to the planning scheme maps of the project area and surrounds. So the committee is not proposing to have a drafting session scheduled into the timetable. Instead, we're proposing to direct the proponent to circulate Part C versions of the documents with its closing submissions if it does propose any further changes to the day one versions. The parties will be given an opportunity to provide written response on the Part C versions within a 5 business day period. Just for the notes of parties at that point, and I'll reiterate then that at that point, some parties may maintain that the projects should not be supported, that any comments on the drafting will be will not be taken as though that does indicate support for the project. It simply provides you with an opportunity to make submissions on what the documents might look like if the projects are to be supported and approved. So that's all I need to run through in terms of the intentions of the committee around the directions. There'll be more detail in the directions letter that gets issued. Mr. Townsend, I'll come to you now. I understand you have a number of things you want to run through.
Thanks very much. Firstly, in the timetable, it's a brief point, but we think where parties are calling evidence, you might want to allow a little more time than the estimates that were provided. The National Parks Association, for example, if there's 2 witnesses, we'd suggest you might want to schedule a day. And where the 2 submitters that wanted to give evidence as well, in case they get questioned, you might want to say give them 2 hours each. It enables time and breaks and questions and answers. And where there are 2 witnesses, it'd be unusual in our suggestion that you'd get that done in a morning, with the submitter. So can I just suggest that you might give those submitters a little more time than they've suggested? But that's a matter for you. On the documents, just so we're clear, and I'd like to make a tweak if we can to the scheduling, but our understanding, which I think is consistent with what's just been said, is that we'd be doing a comprehensive Part A submission. I should say our Part A submission would also include a table, or our first table of responses to submissions. And we want it to align also with matters that might have emerged from our evidence, at least so far as we can for the Part A. But also it's comprehensive in the sense that we want it to stand, as it were, on some topics for the Standing Advisory Committee, more broadly for for subsequent hearings. We were going to ask, so that we can make that align and make it a one-only document, Part A, rather than having to split it, that you might enable us to have till Wednesday the 21st of December for the Part A document. I won't say much more about it unless there's any issue with that, but I can just say that it would greatly assist us with the amount of work that will be needed both for the Part A, but also in parallel with getting the expert evidence and all the other work done, and such that hopefully there are no subsequent or intermediary submission documents needed after the Part A. The reason I say that is what we'd anticipated was our Part B, if you like, which would be a response after the evidence and questioning of witnesses and submissions, would really be our comprehensive reply document. So we're hoping to have a Part A at the beginning of the hearing, not produce another submission for you, and then a Part B at the end, bearing in mind there'll be technical notes or other documents if there are discrete questions. So unless... I think that's what I've understood the committee to say, but so there's no confusion between us, we'd be asking for Part A Wednesday 21st of December and the Part B document as a closing document, but we also will be adding with the Part A a table of responses to submissions, and we would continue to we would meet the directions you've suggested about the day one changes to the incorporated document and the environmental design standards. So as you've suggested, so the only change we'd seek to what the committee has said would be Part A being Wednesday, 21st of December.
Okay, so Mr. Townsend, I'm just going to ask you, apologies if I'm asking something that you've just explained, but I want to be 100% sure that I understand. When you're saying are you suggesting the Part B not be presented at the beginning, an additional written material at the beginning of the proponent's submission?
But what we would do at the beginning is, for the day one presentation, we might have like an outline that's almost like an agenda or showing you what we propose to do. But we don't think you're assisted by argument in a submission document beyond the Part A until we're replying and responding in the light of the evidence. And that's why that would be what we call the closing or the Part B submission. So we wanted to give you one comprehensive submission that responds in light of the questioning of the witnesses and the like, but not give you one in between the part A and the reply. We think it's neater. That's why if you give us longer to do the part A, it'll have more in it. And we can then give you our main written submission as the closing submission, which you would ask for, you know, in advance of the day, obviously. You know, we can make it, you can make a direction at the hearing about that.
So looking at the schedule, Mr. Townsend, that would mean that you were allowing 2 days, only 2 days to review any of the evidence presented by any other party?
No, it really means that we're not saying the part A submission would be argumentative about the evidence. We're suggesting that the best place for that discussion of the evidence is after the evidence has been tested and questioned, both by us of their witnesses and them of our witnesses. And that's why that would all go in the part B, which is actually after the evidence, after the submitters as well. So really that's why we meant by having a day for the closing, because the part B submission would be post evidence, any argument, etc. Obviously, that's not an opportunity for new material or new arguments. If we had anything like that, we would have produced that, whether it's in a technical note or as a document for you in between the two. But so far as the main submissions are concerned, we would hope to limit it to just the part A and the closing part B.
Okay. I will seek the views of any other parties if you have any concerns with that, suggestions. Mr. Townsend, I imagine the standard process of the part A early in that sets the scene, and then the part B that's responding, you're essentially suggesting a slightly different process to that, and the written material to come in.
No, I would have thought what I was suggesting is consistent with major projects I've been on. I don't mean to be rocking the boat. It just seems to me that sometimes the idea that there's this middle submission isn't really that beneficial or useful to you, because it's raising arguments that are yet to be tested through the evidence. So I try to cut out that document. I think you're better served with a part A that's more comprehensive, and that can raise the issues. They can say, these are the issues, but the best submission from us that then deals with them is in light of the evidence as tested, both our evidence and any submitters.
I understand the suggestion and the reason for it. When you just said the only change is moving the part A submission back, does that actually, it does influence, like the part B submission actually would be submitted on a different day to what was proposed in the draft directions?
Yeah, I didn't know there was a part B direction date, but what I'm suggesting is that call it a part B or closing, would be submitted to you before we present it on the last day of the hearing.
The last day of the hearing.
But it would be, so whether that's, depending on what the last day is, if the last day is the 13th, which is a Monday, you might want us to submit the part B on the Friday, for argument's sake, or the Thursday evening before, so that you've had a chance to see it, because we don't want to read it out. But I would commend it to you, as I think the best way for you to be informed is to require us to do a document that is post evidence, but certainly in advance of the close of the actual day of presenting it.
Yes, thank you. Could I just ask if any other party has a view or any comments on that suggestion? No. Okay. Sorry.
I'd just like to say that to make it fair, can other parties put in something on the last day as well?
Dr. Kelly,
I don't really understand, but it has to be fair.
Yeah, so the process is designed so that the proponent can, as the final submissions, respond to anything that's come up through the hearing. So it can certainly, unless there is a really good reason for, and we've talked about that parties would have the opportunity to provide any comment on the EES or the amendment, the amendment documents, and the documents to do with the matter at the end of the hearing. So there would be an opportunity through that, but it would be quite targeted. It is, yes, I think that the process that's described is generally fair, and certainly the committee has a focus on procedural fairness and making sure that parties have the information they need to inform the submission you present to the committee, and then the proponent has adequate opportunity to respond to anything that comes up. Yeah. So on that basis, I'm happy, Mr. Townsend, to go with that suggestion. I note you just mentioned that you didn't realise there was a date for the Part B. Generally, the directions would have the Part B submission the day before commencing the hearing, but I understand the process that you're suggesting, and I can see the merit in it. So, Ms. Mabry, did you just put your hand up, or am I?
Oh yes, sorry, Chair. I had sought to raise my hand slightly earlier. Apologies. I was just interested in that shift in date for the Part B, where the original proposal, as I understood it from the committee, was to enable that Part B written response to submissions and evidence to be with the other parties before they then spoke to their evidence at the hearing. I just wanted to understand if that was the proposed change, that would no longer be the case now.
Yeah, I'll come to Mr. Townsend to explain.
So it wasn't clear. No, the Part A, we would like to bring forward our responses to submissions table. That would be filed with the Part A submission. So that's that would be the 21st of December. Member Kendall, you could leave the direction about the Part B there if you like. I mean, if we want to do a Part B, it would still have to be done then. The real point I'm making is that the comprehensive reply document, whether you call it closing, whether you call it a B or a C, doesn't matter, would be the document that would be done after the evidence. And it would be my practice to make the Part B, therefore, if there is one, a guide of what we're doing at the hearing, but not too discursive, because it really just sits in the middle of the Part A and the closing of the evidence. And in my submission, they're not really useful documents if they're done that way. You end up saying things 3 times instead of twice. So we don't object to there being a direction that any Part A be filed, a Part B be filed by that date. I'm just saying it's not going to be the main document will be the response document. And as to assist with Dr. Kelly's thing, that the point of these hearings is the order. In a sense, all of the objectors or the submitters get a response because they come after the proponent. It's only the reply is for the party that went first, in light of then the evidence and the matters that have been addressed or argued through the submissions. So that's why we'd say the Part A will be more comprehensive. There should be a comprehensive closing submission. If you want to leave a direction about Part B, that can be at our discretion, whether we want to put in a document that helps explain the order of witnesses or the nature of the matters to be presented on day one, for example. Does that make sense?
Yes, thank you, Mr. Townsend. That's clear. So I am generally comfortable with, and I can see the merit in what you're proposing. My only question is if there are any other implications of moving the Part A to the date that you're suggesting, but at a glance, I'm struggling to come up with something that would cause concern. If you've thought through any of the pros and cons associated with that, I'd be happy to hear.
We have. What I haven't said is that it may be that some of the things you've required from us later in January would be ready by then as well. But if that happens, they'll be filed with the Part A. But it's certainly, so it might have the effect of some of the work that's required later being done, but it won't have the effect of shuffling or pushing out any other date. There is an extra direction that I'm going to suggest you make, though, on documents. Can I address you on that now?
Yes, please.
And this will deal with Mr. Decker's comment about the expert elicitation process. And you might have seen in the materials that the department, or under the native vegetation regulations section, had I think our client, the stakeholders, commission a expert elicitation report. And there are 2 steps you'll need to be aware of that might result in a direction you should make. The first is that we anticipate this report being produced in the next, potentially this week, but it could certainly be added to your list of documents that should be released by, I think you'd said the 13th of December or something like that, when you're doing a bundle of documents. We'd be happy for a direction that it be released. The more important point is that, of course, that's an elicitation or expert report it's more of a global document, and what the committee will need to know is what are its implications, if any, for the actual EES. And so when we receive it, we'll need to circulate it amongst the stakeholders and prepare some kind of a response for you. And I'm confident you'll need that response. We don't think we'd be able to do that by the Part A submission, but we think you might want to make a direction that we do that. And if we do it, that perhaps that other date, the 9th of January date I think you had, might also be a suitable date for us to have replied to that, or any reply to the expert elicitation report. So there'd be 2 steps: the report that we received, just provided, and then our response, or our reducing it as we can to the particular facts of the EES by the 9th of January.
Yes, thank you, Mr. Townsend. That's clear, and I'm comfortable with that approach. I failed to mention that there's a number of documents I didn't mention, and I had intended to mention the expert elicitation report, that we would request that if the timing, as you've suggested, works, that I'm comfortable with that, and I understand your suggestion around the response, and that would be very helpful before the hearing starts. Thank you. So to just wrap up on, I'll come back to you in a second, but just to wrap up on a couple of the things we were just talking about. So just a final call to check if parties are comfortable with the suggested changes to the Part A and Part B. So with the Part A to be due on the Wednesday, the 21st of December. I think that Mr. Townsend, leaving in the Part B submission requirement or direction, I think there's still merit in that, but to the extent that it's helpful for the proponent to provide us with information at that stage. Certainly had that experience that you've described of feeling as though you're somewhere in the middle with the Part B rather than having clarity around the position. So I'll check the wording of the Part B to make sure that it accommodates that. That's generally scheduled to be provided the business day before the hearing commences, so it would have been the 16th of January. And I'm happy to accept your suggestion on those other directions, so thank you, that's great. Mr. Townsend, was there anything else that we needed to cover off on procedurally from your perspective?
No, there are matters. Thanks very much.
Thank you. So I will close the hearing in a few minutes. I'd just like to see if any other party has any other procedural matters that we need to discuss or any questions. Dr. Kelly, your hand is up still. I'm just checking if that's meant to be.
I wanted to say that I'm concerned about how confusing all that stuff was with dates and stuff there. I can't take that all in without it written down. But it's good that there is some flexibility for other parties, because it means there should be some flexibility for the people who are from the community who I won't say again the situation we're in, but some people didn't get to put in submissions. The other thing is that with the packages, the 4 packages that you've split these projects into, there is an opportunity to meet in Robinvale for these ones, Hattah and Belsar, to meet in Mildura for Lindsay and Walpola, to meet in Swan Hill for Naya, Vinifera and Burra, and to meet in, say, Kahuna or Kerang for Gunbower. And I just put it to the committee and the chair through you that would be a very fair and good thing to do, because access to this process is important. These projects are massive. They will have a massive input, massive change for communities and the way we see the landscape. And it would be fair to not expect local people to have to be so onerous to participate in regards to going to Melbourne or being online, so that's my request, is that you go to the town and community that is the closest to those projects, because some people who are participating in this will just walk away and never think about it again. and other people are going to live with it every single day of their lives and into the future generations of these communities who these places are right near and are part of their culture and deeply connected to.
Thank you, Dr. Kelly. And yes, thank you for sharing those thoughts. The community does appreciate understanding the context and the experience for the community. We'll work closely with the proponent through this matter to determine an appropriate location for a online/hybrid hearing, if that's, in-person and hybrid hearing, if that becomes possible.
If I could add, the proponent has handballed some of these consultations to the Mallee CMA, who have said to me, Jane Ryan said to me when she met with me in Swan Hill, that they won't have a public meeting in Swan Hill because they're worried for the safety of their staff, which I said to her was highly offensive, and that she doesn't know our community if she says things like that. So I just want you to understand that the proponent and the Mallee CMA have not behaved fully respectfully in this matter.
Thanks, Dr. Kelly. Well, it's outside of the scope of discussion for today, and if you anything material to your submission, you're welcome to present to the committee. I'm sure the proponents heard your views there today as well. Just in relation to your first point, with it being a bit difficult to follow the discussion around the directions and the dates, the directions letter will be issued after the hearing today, so over the next few days. If you have any questions regarding the process, you're welcome to contact the Planning Panel's Victoria office to get clarification and to assist you. I've noted your comments regarding the hearing venues to the extent the committee can influence that or accommodate that we'll take that into consideration as we work through the matters. I can't speak for the future matters. It'll be up to the chair of those how that's managed at the time. So if there are anyone else wishing to say or ask any final questions? No, thank you. So just in terms of compliance with the committee directions, I just need to make mention that all directions with the committee must be complied with. Parties are reminded that it's an offence under the Planning and Environment Act to fail to comply with the directions of the advisory committee. If you anticipate not being able to comply with the direction, such as meeting a deadline, you'll need to provide the committee with advance notice and an explanation as to why you are unable to comply with the direction, and to seek leave from the committee to vary that direction. The committee may refuse to hear from anyone who fails to comply with the direction and may not accept evidence if leave to vary a direction for the circulation of evidence is not sought or granted. And if I could just please emphasise to all parties how critical it is compliance with the time and date for provision of information and expert evidence. Everybody is relying on everybody else in these processes, and there are implications if timelines are not met and hasn't been communicated clearly to the committee or the party. So I just ask people to give that some serious consideration, please, and to make every effort to comply with the timeframes. As I just mentioned, after today, we will circulate the directions based on what we've outlined verbally, along with a timetable for the hearing and a distribution list. You can expect to receive a copy by the end of the week. And I'd just like to say thank you very much to everybody for your participation. I was going to say this morning, it's no longer morning. It's been a relatively long directions hearing, but we've covered off on a lot of matters, and from the committee's perspective, I thank you all for your contributions and for assisting us to ensure that we're able to prepare adequately for the hearing in January. So thank you, and I look forward to seeing you at the main hearing. Thank you very much.